Hello class. Good evening sa inyo. So, we will continue with our discussion with the Revised Corporation Code of the Philippines kung saan nung una na-discuss na natin yung Title 1, yeah? Yung basically general provisions about the corporation laws dito sa ating about the Revised Corporation Code that basically the general law the general law that governs the private corporations dito sa ating bansa. So, parang introduction lang siya. Ngayon, we will go to Title 2, which basically talks about the incorporation and organization of private corporations. So, let's start. Kailan pinag-usapan natin dito is paano pinanganak ang isang corporation, paano siya na-form, kumbaga. And specifically, talks about the private corporations kasi 'di ba napag-usapan natin na some corporations are not all corporations are not created equal, 'di ba? Some special charter that is specifically promulgated by the legislative for their creations. 'Di ba kasi dalawang types or dalawang ways na create yung isang corporation. Ito, recap lang. Nung una is to a general law for that governs its incorporation. Specifically, in our time, it's the Revised Corporation Code of the Philippines. And the other way is through a special charter or special law created for its creation, promulgated for its creation. So ito, we're talking about a general corporation law, general corporation code, which governs the creation of a corporation. And this is discussed in the Title 2. Sorry if medyo pa ako ngayon, medyo hindi pa maganda yung pakiramdam ko, but we will continue with our discussion. So ito, nag-stop tayo sa Section 9. Let's go to Section 10 of the Code. So itong sa Section 10 talks about the number and qualifications of incorporators. So ito, any person, partnership, association, or corporation singly or jointly man with others, but not more than 15 in number, may organize a corporation for any lawful purpose or purposes, provided that natural persons who are licensed to practice a profession and partnerships or association organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless otherwise provided under special laws. Incorporators who are natural persons must be of legal age daw. And with that, each incorporator of a stock corporation must own or be a subscriber to at least one share of capital stock. A corporation with a single stockholder is considered a one-person corporation as described in Title 13, Chapter 3 of this code. So later on pa yan. So ito, basically isa to sa mga biggest changes ng ating corporation code kasi as compared to BP 68, which is our old corporation code, itong Section 10 is one of the biggest changes sa ating revised code. Bakit? Ito, as provided in the salient marks or remarks about the revised code. Dati kasi, sa ating old code, yung BP 68, any person lang ang nakalagay. Any person lang. Ngayon, even partnerships, associations, or corporations themselves, singly man or jointly, sila lang mag-isa or may kasama silang iba, may now form a corporation pursuant to this new law. Oo, kasi dati, person lang, natural persons lang, generally ang pwedeng magtayo ng corporation. Ngayon, di ba, as gaya ng diniscuss natin sa previous video natin, na mas pinadali na basically ng batas yung formation isang corporation. So ngayon, hindi lang tao, hindi lang natural persons ang pwedeng incorporate ang mag-start ng corporation, but rather, even partnerships, association, and other corporations, pwede na. Another easement for the creation of a corporation is the removal of the requirements as to the minimum number of incorporators. Oo, kasi dati, ang nakalagay dyan is 5 to 15. Oo, at least at minimum of 5, maximum of 15 incorporators. Pero ngayon hindi na. Tinanggal na tong minimum 5. Ang tinira na lang dyan is yung maximum 15. So, ibig sabihin, kahit isang tao, pwede nang mag-start ng corporation. O, nilagay nga dyan singly, kahit isang isang entity lang, pwede na mag-start ng corporation. Pwede lang na isang incorporator. And because of that, introduction of the OPC or the one-person corporation. So, since tinanggal yung minimum, ibig sabihin, kahit isang tao lang, pwede nang. Kahit isang entity lang, kasi kahit partnership, association, or corporations, pwede. Isang tao o isang entity, pwede nang mag-start ng corporation. Oo. So, basically yung isa sana, yun yung biggest changes pagdating dito sa Section 10. O biggest changes overall sa ating corporation code. Etong pagtatanggal ng minimum number of incorporators, tinira na lang yung 15, maximum 15. So, kahit isang entity lang, pwede nang mag-start ng corporation. Now, incorporation of a private corporation is a mere privilege. Pribilehiyo, kumbaga. Agreement alone are not sufficient for a corporation to exist. Oo, kasi di ba partnership natin? Oral man o written contract or agreement nila, pwede na silang mag-start ng partnership. Sa corporation, hindi ganon. Mere agreements are not enough, are not sufficient para magtayo ng corporation. Bakit? It is necessary na mayroong legislative authority to obtain or be obtained to put a stamp of state intervention in the creation of corporation, such power being one of the attributes of sovereignty. Ibig sabihin, kailangan ng intervention. Kailangan umepal dyan ng ating gobyerno, ng state mismo, para sa pagtatayo ng isang corporation. Because it is an attribute of sovereignty. Kapangyarihan yan. It is his sovereign right to do so. Bakit, sir? Sa partnership, hindi ganun ka-stricto. Pagdating dito sa corporation, epal na si gobyerno. Well, basically, of how greatly or gaano kalaki, basically, nakikalimutan ko ang English nun, how big is the impact of the corporation when it comes to society. Kasi considering the size of a corporation compared mo sa size ng isang partnership, masasabi mo, mas malaki yung impact yun. Impact ng isang corporation sa society as compared sa isang partnership. Because of this impact, because of how greatly a corporation affects the society, its surrounding, kung saan man to siya nag-ooperate. Sabi ng state, because of that, we need to intervene. We need to make sure that this corporation follows the rule of law, follows the regulation. Kaya, kailangang umepal, basically yung intervention, kailangang umepal ng state when it comes to the creation of a corporation in order to make sure that the corporation follows the rules and regulations. Oo, because of how greatly it affects the society. Yun yung rationale behind that. Kaya, incorporation of a private corporation, it is not a right, but it is a privilege. Anong mga rights natin? Right to education. Right, academic freedom. Right to life. Diba? Those are rights. It is granted to you. Wala kang kailangan gawin. It is granted to you. Pero ang privilege, hindi yan granted to you. You need to follow the requirements, the conditions necessary in order to gain that privilege. Bakit? Because granting a privilege means that you need to be in a position where you can properly perform what is granted in that privilege. In this case, corporation. Ganun lang yung kasimple. Now, under Section 10, the formation of a corporation for any lawful purpose or purposes, provided it is in accordance with the code, is a matter of right and cannot be restrained. Sir, di ba sabi nyo hindi yan right, but rather privilege? Terminology lang yan, class. Kasi tingnan nyo, di ba ang right, kahit wala kang gagawin, granted na yan sa'yo. Ang privilege hindi. May kailangan ka pang i-follow na requirements, ma-follow na conditions bago mag-grant sa yung privilege. As you can see here, kung babasahin nyo, ang formation ng corporation, dapat for any lawful purpose or purposes lang. O yan yung condition, yan yung requirement. Kapag unlawful purpose yan, hindi yan i-grant sa'yo. So, terminologies lang yan, terms lang yan. pero privileges talaga yan. Kailangan may follow kang requirements, kailangan may follow kang codes, conditions bago i-grant sa'yo yung creation ng iyong corporation. Ganun lang yan. Ngayon, we're talking about the creation, the formation of a corporation. So, paano ba siya nakikreate? Paano ba siya na-formulate? Formulate. May tatlong steps tayo dyan. Tatlo ba yun? Oo, tatlo yun. Una, yung promotion. Ano tong promotion? Basically, hindi ito yung sa mga yung sa yung sa trabaho mo. Pag magaling ka sa trabaho mo, napopromote ka, etc. etc. Hindi, iba. Iba tong promotion in this concept or in this context. In business term, kasi corporation business. In business term, business operations peculiar to the business world by which a company is generally, brought into existence. So, yun yung promotion dito. You're trying to bring into existence a certain entity. In this case, a corporation. Yan yung meaning ng promotion in this context. Bringing into existence an entity, which in this case is a corporation. Now, the formation and organization of a corporation are brought about generally at the instance and under the supervision of one or more persons called promoters, mga promotor. Sila yung responsible sa pag-bring into existence ang isang corporation sa formation and organization nito. Sila yung Sila yung nagli-lead ba? Sila yung nagtatrabaho talaga, nag-work para itong corporation na to ma-bring into existence, ma-form. Under their supervision and guidance yan. Mga promoter ang tawag, di ba na-discuss natin to kanina? Last discussion natin, di ba yung mga promoters, underwriters, sila yun. Now, a promoter of a corporation is one who, alone or with others, so lalo na pag malaking corporation yan, may kasama talaga yan may mga kasama yan sa pag-promote or bring into existence ng corporation, sa pag-form ng corporation. Alone or with others, takes it upon himself to organize a corporation, like to procure necessary legislation kapag kailangan, like special charter or special laws ang kailangan para i-create yung corporation or kahit i-follow na lang yung general corporation law. Kasi di ba sabi natin two ways meron. O kasi where that is necessary, another way is for them to procure necessary another thing for them to do in the formation of the corporation is yung to procure the necessary subscribers to the articles of incorporation. Ito, corporation organized under general laws to see that the necessary documents presented, certificate and general to float a company. Basically ito, ginagawa ng isang promoter to bring into the existence a corporation para mag-form, para mag-organize ng corporation. So ito basically mga examples ng kung anong ginagawa nila. Basically sila yung lead Sila yung pasimuno ba? Now ito, stages in corporate promotion. So, sa corporate promotion, which is basically this, bring into existence, ano yung nangyayari within that promotion process? Tatlo tayo meron. Una is the discovery. Anong nangyayari sa discovery? Well, in this stage, may represent a new product service or the promoter may simply organize another company in an existing line of business. Ibig sabihin, parang ganito. Parang itong na-discover nating new product, let's say electric airplane, kumbaga. Kasi hindi pa yung mass produce mga experimental pa lang meron ngayon. So ito, electric airplanes, new product, new service. Naisip nila, maganda tong market to benta-benta to Parang electric cars. So yun, because of that new product service, naisipan nila magtayo ng corporation. That is the discovery. Na there must be a way. Na there must be a platform kung saan pwede nating i-market itong electric plane na to. And since electric plane are big business or requires big capital, big business, anong gagawin mo? Magtayo ka ng corporation. So yan, discovery. Of a new product or service. Or pwede rin, mag-penetrate ka na lang sa existing market, existing line of business. Like for example, electric cars, electric vehicles. Yung like sa Nikola, so, yung inaano ng General Motors sa Amerika. So, existing market na yan eh. Yung electric cars. So, with that, naisipan mo, gusto ko mag-penetrate dyan sa market na yan para magkaroon ako ng share dyan. So, papasok ka yan. Create ka ng another corporation for that penetration of an existing market for electric cars. So, that discovery. Ibig sabihin, aminin lang yan, gusto mo magtayo ng business. Meron kang product. Gusto mong magtayo ng business. Discovery yan. Yan yung discovery. Ibig sabihin yung purpose mo para magtayo ng corporation. Ngayon, investigation tayo. Meron ka ng product. Gusto mong magtayo ng business through incorporating, through establishing a corporation. Ngayon, you will decide or you will now think, worth it ba na magtayo ako ng corporation para i-market itong product ko? Worth it ba? Para magtayo ako ng corporation para i-market tong service ko. Paano malalaman? Investigation. Parang feasibility studies na yung gagawin nyo dito. The second phase involves analysis of needs, financial management, plant material level, and decision whether the estimated earnings justify the effort. Parang feasibility study na to. Titingnan mo. Papag-aralan mo. Na worth it ba lahat ng efforts mo? Lahat ng gagastusin mo para sa pagtatayo ng corporation to do business? Will it justify the money inserted and the efforts exerted? Sa investigation yung malalaman. Ngayon, dito sa investigation na nalaman mo na lumabas yung result, na worth it naman. Kikita ka. So with that, pasok ka na sa stage 3, the assembly. Dito sa last stage, it consists the bringing together the property, money, and personal into organization. So basically lahat ng capital mo, labor man yan, labor capital, human capital, actual property capital, or capital mismo na pera, hahanap ka na yan. Saan ka makakuha niyan? Kasi gagamitin mo sila sa pag-business mo, sa business operations mo sa iyong corporation. At this stage, the promoter must have some assurance of control lest third parties deprive him of At this stage, the promoter must have assurance of control. Big sabihin, since may control ka na over that, yung pag-form mo ng corporation, goods na. Magagawa mo na. Lest third parties deprive him of the fruits of his efforts, control may cover such items, for example, patent, lease, options, property, and other contract services. So ito, discovery. So ito, tatlong stage. Sa discovery, kumbaga, itong mga tao or itong promoter, mayroon siyang product, mayroon siyang services, gusto niyang mag-business. And nakita niya na corporation yung magandang platform para i-market niya yung kanyang product or service. Pagdating sa investigation stage, titingnan niya kung basically worth it ba na mag-insert siya ng capital at mag-exert ng effort para sa business niya. Sa gusto niyang itayong business through the platform of corporation. Pag naisip niya na worth it naman, assembly na, dyan na. Mag-start na siyang magkalap ng pondo, ng capital, human, labor, actual capital, money capital, etc. etc. Para yun yung gagamitin niya sa pag-establish, sa pag-operate ng kanyang business. That is the stages in corporate promotion. Parang typical lang, di ba? Parang typical business lang. Typical business, typical startup ng isang business. Ngayon, di ba? The second step in the creation of a corporation, kasi ang una is the promotion. Dito na tayo sa incorporation. Nandito kasi sa promotion, basically ang ginagawa dito is kailangan prepared ka muna. Kailangan ihanda mo na lahat ng kailangang ihanda before kang mag-form ng isang corporation. Pag ready ka na, dito ka na, papasok ka na sa second step, which is incorporation. Now, before that, let us discuss the distinction between a corporation and incorporation. Kasi baka malito kayo. Iba yan silang dalawa. Ang corporation, yan yung legal or juridical institution. Yan yung artificial being. Yan yung tinayo mo. Itong incorporation, ito yung process, ito yung act by which the institution is created. So, ito yung creation, ito yung process kung paano mo ginawa yung creation. O, yeah? Ito yung result, si corporation. Ito yung process, si incorporation. So don't forget that. Now, with that, ano ang mga steps within this incorporation, within this process? Ang unang step is drafting and executing the articles of incorporation by the incorporators and other documents required for registration of the corporation. Pangalawang step is yan, na-drop mo na yung articles of incorporation and other necessary documents. Anong next? Ifa-file mo na yan sa Securities and Exchange Commission to yung articles of incorporation mo. Ngayon, ito advance note lang. Isa sa mga salient points or mga improvements, innovation ng ating revised Corp Code is pwede na ang electronic filing. Dati kasi hindi. Alangan, kasi 1980 yung natin yung old corporation code. So, wala pa yung concept ng electronic filing. But since ito, 2019, ang ating revised corporation code, itong filing ng articles of incorporation and other necessary documents with the Securities and Exchange Commission, pwede na ang electronic filing. Yun. Additional advance note lang. Together with the following, kasama ng articles of incorporation are the following documents na required. Dati kasi required pa ang treasurer's affidavit. Kung ito, ngayon hindi na. Bakit? Kasi 'di ba sinabi na natin na hindi na kailangan yung kasi dito sa sa dating corporation code, sa old code, yung BP68, kailangan pa yung requirements ng 2525. Now, if you can remember sa inyong accounting for partnership incorporations, nandun yung 2525 rule, di ba? Na at least 25% of the authorized capital has been subscribed and 25% of that must have been paid. Di ba? Ngayon, hindi na yung kailangan. Hindi na yung kailangan. Tinanggal na yon. So, with that removal, nawala na rin ng purpose yung treasurer's affidavit. Kasi itong treasurer's affidavit, yung treasurer ng corporation nyo, nang gusto nyo itayong corporation, i-attest niya dyan na yung 25-25 rule was followed. And since yung 25-25 rule is not required anymore, wala nang purpose si treasurer's affidavit. So, tinanggal na yan siya. Okay? Ngayon, dito itong number 2, in case the corporation is governed by special law, like educational institution, formation of banks, a favorable recommendation of the appropriate agency, like dito, Department of Education, Culture, and Sport, that such article of incorporation is in accordance with the special law. Mga PDIC, general banking laws. Pagtatayo ka ng bank, hindi lang ka basta-basta magtatayo ng bank. Kailangan mo ng recommendation of the appropriate government agency. Dito, kapag educational institution, kailangan mo ng DepEd. DepEd recommendation. Pag bangko, monetary board yan ng ng bangko, central bank natin yan. So yan. Mga additional notes or additional documents na kailangan kapag isasubmit mo o i-file mo ang iyong articles of incorporation. Pangalawang step, magbabayad ka ng filing and publication fees. Of course, libre. Privilege yan Pangalawa, kapag approve na yan ng SEC, nakita nilang walang mali sa iyong, walang error sa iyong documents, then yung SEC mag-issue na ng Certificate of Incorporation. If all the papers filed verification of external account in order. Now, take note, the life of a corporation starts at the issuance of the COI. Di ba sa partnership, yung existence, yung juridical entity ng partnership only exists unless otherwise provided at the execution of the contract. Diba? Unless otherwise provided sa kanilang articles of partnership. Dito sa corporation, the legal existence of the corporation starts with the with the issuance by the SEC of the Certificate of Incorporation. Tandaan niyo yan. Nalalabas na sa board exam. Now, there are rules or requirements under special laws to be complied with in organizing specific business and to endow the corporation with the capacity to transact business for which it was created. So, yung additional rules. And lastly, itong slide na to, take note. Diba? Sabi natin, dati kasi sa old code, BP68, natural persons lang. Ngayon, pwede na partnerships, associations, and other corporations. Ngayon, kapag natural person, yung incorporator, may certain requirements. Of course, natural person. Una, dapat tao siya. Obviously. Capacity to enter into contract. Obviously. Residente ng Pilipinas ang majority ng incorporator pag natural. Kasi mayroon tayong rule na general rule is 60-40. 60% must be owned by Filipinos, 40% at least 60% must be owned by Filipinos, the rest 40% pwedeng foreign yan. General rule yun general rule yun kasi may mga special rules pa tayo na kung saan for this certain type of business, certain type of organization, may specific number kung ilan yung or percentage kung ilan yung ownership ng Pinoy as compared to corporations, as compared to foreign. But yung general rule is 60-40. 60 Pinoy, 40% is foreign. Citizen ng Pinas, based on required Pinoy ownership and owners, obviously owners of a subscriber, at least 1 share. Meron sila. So yan. Basically yung section 10 natin talks about the qualification, incorporation, etc. etc. Now let's go to section 11. So ano tong sasabi sa section 11? Yung topic dito section 11 is all about the corporate term daw. So, a corporation shall have perpetual existence unless its articles of incorporation provides otherwise. So from the wording itself, it is understandable na yung buhay ng isang corporation pwede continuous yan. No need nang mag-file pa ng anything with the commission. However, kapag stated sa articles of incorporation nito na may limited existence siya, fixed kumbaga, yun yung masusunod. So, ito, isa to sa mga salient changes sa revised corporation code natin. Kasi dati, it was 50 years. Maximum 50 years, pero pwede ka mag-renew. Now, in this new corporation code, in this revised corporation code, tinanggal na yung 50 years Nilagay na lang na perpetual existence. Ibig sabihin continuous. Not necessarily immortal like habang buhay, but perpetual, continuous yan. Unless, sa Articles of Incorporation, may nakalagay na fixed term. Yan, isa yun sa mga salient changes ng ating revised corp code. Now, corporations with certificates of incorporation issued prior to the effectivity of this code, ibig sabihin mga past corporations, yung mga corporations under the that was incorporated under the previous law and which continue to exist shall have perpetual existence. So, automatic by operation of law, kahit nakalagay sa kanilang articles of incorporation na may fixed term sila, by operation of law, automatic perpetual existence sila. Kahit wala silang ginagawa on their part. However, that is the general rule. May exception yan. Ito yun. Unless the corporation, upon a vote of its stockholders representing a majority of its outstanding capital stock, notifies the commission that it elects to retain its specific corporate terms pursuant to its articles of incorporation. So, yan yung exception. Kapag pinili ng majority ng stockholders na ayaw namin ng perpetual existence, gusto namin i-follow pa rin yung fixed term na nakalagay sa articles of incorporation namin, then go. They can do that. They will notify the commission, the Securities and Exchange Commission, na ipa-follow nila yung fixed corporate term na yun. Now, provided that any change in the corporate term under this section is without prejudice to the appraisal right of dissenting stockholders in accordance with the provision of this code. Diba, napag-usapan natin ito sa previous video, itong si dissenting stockholder. Pero later on, madidiscuss natin yan sa further. But basically, itong si dissenting stockholder, if there are any changes in the corporation that would affect this stockholder, na kung saan ayaw niya yung ganung changes, kasi may adverse effect daw sa kanya, then he can elect na sasabihin niya, parang ayaw ko ng change na yan So, gusto ko mag-withdraw na lang. So, kung ganun yung mangyayari, then, i-appraise yung kanyang stocks. Basically, kung anong fair value nun, yun yung ibabayad sa kanya. So, yun yung basically yung nature ng isang dissenting stockholder. Na-discuss na natin to on the previous video, if you can still remember. Ngayon, a corporate term for a specific period may be extended or shortened by amending the Articles of Incorporation. Oo, pag example, hindi perpetual yung inelect nila, may fixed term pa rin. Now, of course, they can still amend that para may ilagay silang anong changes man yan. Whether i-extend man nila or isusorten, pwede yon. Oo, i-amend lang nila ang kanilang Articles of Incorporation. However, provided that no extension may be made, extension may be made earlier than 3 years prior to the original or subsequent expiry dates unless there are justifiable reasons for an earlier extension as may be determined by the Commission. Like for example, let's say January 1, 2020, yung expiry date ng corporation nyo, yung fixed term period. Ngayon, hindi kayo pwedeng mag-file ng amendment to extend the life of the corporation within earlier than 3 years. Ibig sabihin, the earliest that you can file an amendment to extend the life of the corporation is 2019, 2018, 2017 is January 1, 2017. That is the earliest na pwede kayo mag-file ng amendment to extend the life of the corporation. But that is the general rule. Pwede nyong i-circumvent yung general rule na yan na makapag-file pa kayo on later dates before January 1, 2017 if there are justifiable reasons for an earlier extension. Na kung saan si SEC yung magdedetermine if justifiable reason nga para mag-grant sila ng earlier extension. So yun, take note lang. Now, provided further that such extension of the corporate term shall take effect only on the following day of the original or subsequent expiry date. Like, gaya na sabi natin, ang expiry date was January 1, 2020. So, magte-take effect lang yung extension na yun on January 2, 2020. So, yun lang meaning mo. Basic na, understandable naman, Kasi layman's term naman, hindi naman ganun ka-complicated yung pagbigay ng provisions. A corporation whose term has expired may apply for a revival of its corporate existence, together with all the rights and privileges under its certificate of incorporation and subject to all of its duties, debts, liabilities existing prior to its revival. Upon approval by the Commission, the corporation shall be deemed revived and a certificate of revival of corporate existence shall be issued, giving it perpetual existence unless its application for revival provides otherwise. So, dito, in this case naman, basically talks about hindi nakapag-file ng amendment yung corporation, yung officers and members ng corporation na yun for the extension of its life. Oo, hindi sila nakafile. So, since hindi ka nakafile, dumating yung expiry date, boom, patay na yung corporation. Basically. Now, pero nag-decide sila, mga people in that corporation na gusto nilang buhayin. Oo, revive ang ginamit Revive word yung ginamit. Gusto nilang buhayin yung corporation. Gusto nilang i-continue yung doing business. Or operations. So with that, they will file with the commission for the revival of the corporation. Kasi nga, namatay yung corporation Dumating yung expiry date niya. So para mag-operate pa siya, para maka-legally operate pa siya ulit, revival ang kailangan. So yun. Napaka-basic, di ba? No application for revival of certificate of incorporation of banks, banking and quasi-banking institution, pre-need, insurance and trust companies, non-stock saving and loan associations, pawn shops, corporations engaged in money service businesses, and other financial intermediaries shall be approved by the Commission unless accompanied by favorable recommendation of the appropriate government agency. Now, as you can see here, ano to sila? Basically, mga financial institutions yan sila, di ba? Mga financial institution. So, pag namatay sila, pag namatay yung corporation nila, so kailangan nila mag-application for revival. So, however, hindi yan pwede ma-approve ni Commission, ni SEC, kapag walang favorable recommendation of the appropriate government agency. In this case, since these are financial institutions, monetary board to ng central bank natin. Ito yung ito yung appropriate government agency for these financial institutions na kailangan mayroon silang i-release na favorable recommendation para i-approve ng SEC yung kanilang application for revival. Considering that these financial institutions are very crucial to our society, to our economy, kaya bago sila ipa-operate ulit, kailangan papag-aralan pa yan ng appropriate government agency kung kaya ba nila na mag-operate pa ulit, considering na namatay sila because of the expiry of their corporate term. So yan, napaka-basic ng Section 11 natin. Ito yung mga salient points or salient remarks that was changed that is different from the previous code, BP 68, to this revised code. Ito, na-mention natin that the revised Corp code introduces perpetual existence of a corporation by removing the maximum corporate term of 50 years unless specific term is provided sa kanilang AOI. Yan. Kasi dati 50 years talaga yung max hindi nila pwede ma-perpetual yan. So, ngayon, pwede na. Kasi nonsense Kasi itong 50 years, unlimited unlimited amendments to Oo. Pwede mong unlimited extension pala, Oo, pwede mo extend. Unlimited extension ka meron. So, since na lagyan mo ng 50 years maximum diyan, tanggalin mo na lang kasi may unlimited extension naman So, gawin mo na lang perpetual. Yun, logical. Yun yung logical na ginawa. Kaya tinanggalin yung 50 years kasi nonsense na lang because of the existence of unlimited extension. Kaya perpetual na lang ang nilagay. Corporation duly registered with the Commission prior to the amendment of the Corporation Code shall be deemed to continue to exist having perpetual existence by operation of law yan Sinabi ng batas. Unless a notice given to the SEC that the majority vote of the shareholders decides to keep with the specific terms na nakalagay sa kanilang AOI, Articles of Incorporation. Now, corporation which opted specific term and wishes to extend the corporate life may apply within 3 years. Dati, previous law natin was 5 years, ngayon 3 years na lang. Prior to the expiry. Nahulog ang cellphone. Any early application for extension may be approved only kung may justifiable reason and ang magdidetermine yan is yung Commission, the Securities and Exchange Commission. Ito, kapag yung corporation, yung may expiration date pa rin yung sa kanilang AOI, hindi nila finalo yung perpetual. Ito yung mga concepts under that. Limitations. The extension of corporate term is subject to the following limitations. The amendment is effected before the expiration of corporate terms after dissolution, hence extension cannot be during the 3-year period of liquidation. Ito, basahin nyo na lang. So, effect of extension of corporate term, automatic extension of term, 5-year period. So, let's go to Section 12. Itong Section 12, basically, wala to siyang changes from the previous corporation code natin. Ito pa rin yun siya. So, minimum capital stock not required of stock corporation. Stock corporation shall not be required to have a minimum capital stock except as otherwise specifically provided by special law. Now, itong Section 12 na to, sa previous corporation code natin, sa BP 68, medyo nag-nonsense itong Section 12 natin. Oo, nag-nonsense siya. Bakit? Explain ko sa inyo. Sa previous code kasi, meron tayong tinatawag na 25 rule. And may minimum paid up capital of 5,000. Oo, ibig sabihin, bago i-approve ng SEC yung corporation ng application for yung articles of incorporation mo, mag-issue sila ng certificate of incorporation, dapat at least meron kang 5,000 paid up capital. Ibig sabihin, 5,000 yung nabayaran ng capital sa authorized capital stock mo. Now, following this 25-25 rule, Itong 25% 25% ng authorized capital stock mo must be subscribed. And 25% of that subscribed capital must be paid na. Oo, 25% ng subscribe mo, ng subscription mo, must be paid. Now, idikit mo yan dito sa 5,000 natin. Ibig sabihin, 5,000 paid up capital minimum divided by 25%. Dapat, at least yung authorized stock capital mo must be 20% at 20,000. Gets nyo yung algebraic logic nito? Okay, ulitin ko. Sa previous corporation code natin kasi meron tayong 25-25 rule na kung saan sa authorized capital stock na nilagay mo sa iyong articles of incorporation, 25% must be subscribed na. Ibig sabihin may subscription na yan. May bibili na. Then 25% out of that 25% must be paid na. So, ibig sabihin, paid up capital na or paid subscription na. Now, in this case, additional provision from the law provides that, if I remember correctly, Section 13 yan ng previous law, which in this revised, tinanggal na. So, nakalagay doon na dapat yung paid up capital mo is at least 5,000 pesos. Now, idikit mo yan sa 25% na dapat bayad na. Out of the 25% na dapat subscribe na. Meaning lang yan, dapat may 20% subscribe ka na. Now, i-divide natin to. Maganda to explain pag face-to-face eh. Problema talaga itong 20% divided by 25. So, dapat at least 80,000 na. Or at least 80,000 yung iyong subscribe capital. Or I mean yung authorized capital mo. Yung capital stock mo. 80,000. Bakit? Kasi following the 25-25 rule i-work back mo yan. Paid up capital must be 5,000. So, 25% yan. Paid kasi. So, divide mo by 25%. So, yan, 20,000. Na itong 20,000, yan yung minimum subscribe dapat. So, 25%, di ba? Di ba? So, yan 20%, which is the 20,000, which is the 25% of the subscribed, that the authorized capital stock must be subscribed. So, para malaman mo kung ilan na authorized stock capital meron, divide mo ulit by 25%, which will lead you to 80,000. Now, ganyan sa natin. Sa previous code natin, na kahit may ganitong provision ng Section 12, na walang minimum hindi required na may minimum capital stock. Pero on the subsequent section, may nilagay na 5,000 dapat yung paid up capital. Nonsense, di ba? Oo, nonsense. Kaya yung Section 13 tinanggal na. Para ma-follow talaga itong essence ni Section 12 na stock corporation shall not be required to have a minimum capital stock except as otherwise specifically provided by a special law. Itong general corporation, itong corporation code niya naman to special law eh. General corporation law to siya eh. Oh, kaya tinanggal na yung Section 13. Oh, basahin niyo yung Section 13, nakalagay doon yung 25-25 rule and yung minimum 5,000 paid up capital. So, it will go in conflict with Section 12 eh. Kaya tinanggal na lang nila. So, yun, additional note lang yun sa inyo. Ito naman, basahin nyo na lang. Kasi, sa natin, di ba, ito? Except as otherwise specifically provided by law, di ba na-mention natin kanina, in the last video natin, na kapag may foreign ownership sa isang corporation, the general rule is 60-40. 60% ang ownership sa Pinoy, 40% sa foreign. However, there are certain specific provisions ng ating batas na kung saan it specifically said or states kung ilang percentage of Filipino ownership meron, minimum, bago maging valid sila, legal. Oo, and these are yung listed for the Corporation for Exploration, Public Service Corporation, Educational Corporation, O corporation engaged in mass media and advertising. O, dyan no? O, di ba? Kung naano yung si Rappler, ito yung 100% ownership niya, yan yung isa sa mga pinaglalabanan against sa kanya. Yan. Banking corporations, corporation engaged in retail trade. May specific provisions sa corporation natin, or natin sa corporation, batas natin, when in regards to corporations, kung ilang Filipino ownership meron. Basically, it is to protect the to protect the economy, to protect the society from foreign intervention. Kaya, binigyan ng minimum for Filipino ownership yung ating mga corporations. Yan. So, yan, basahin nyo na lang. But, take note of this, wala tayong minimum capital stock. On the previous corporation code, it was not properly followed because of the 25-25 rule and the 5,000 paid up capital. Ngayon, kahit wala nang sinasabing minimum capital stock, it is properly followed na. So, continuing with discussion, let's go to article section 13 of the code. So, itong sa section 13 ng code natin, basically it prescribes for the contents ng ating articles of incorporation. Now, itong articles of incorporation, this is required for all corporations. Sorry. It states that all corporations shall file with the Commission articles of incorporation in any of the official languages, duly signed and acknowledged or authenticated in such form and manner as may be allowed by the Commission, containing substantially the following matters except as otherwise prescribed by this code or by special law. So, ito yung mga, at the very least, laman ng isang articles of incorporation. Name ng corporation, specific purpose or purposes for which the corporation is being formed, where a corporation has more than one stated purpose, the articles of incorporation shall indicate the primary purpose and the secondary purpose or purposes, provided that a non-stock corporation may not include the purpose which would change or contradict its nature or as such. Pangatlo is that the place where the principal office of the corporation is to be located, which must be within the Philippines, obviously. Pinoy corporation. The term for which the corporation is exists if the corporation has not elected perpetual existence. The name, nationality, residence ng kanyang addresses of the incorporators, the number of directors which shall not be more than 15, or the number of trustees which may be more than 15. So, ang directors sa stock corporation, ang trustees sa non-stock. The name, nationalities, and residence addresses of person who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code. If it be a stock corporation, the amount of its authorized capital stock, number of shares into which divided, the par value of shares, nationalities, residence address, etc., etc. Ito naman kapag non-stock, the amount of capital, names, nationalities, residence of contributors, and the amount contributed by each. And lastly, such other matters consistent with law and which the incorporator may deem necessary and convenient. So, ito basically at the very least ang laman ng isang articles of incorporation. Now, additional to sa additional provision to, additional item to sa provision sa revise. Na kung saan, an arbitration agreement may be provided in the articles of incorporation pursuant to Section 181 of this code. The articles of incorporation and application for amendments thereto may be filed with the Commission in the form of electronic document. Ito rin. Isa to sa mga innovations sa revised Corp Code natin. Itong filing through electronic document, electronic filing. Na-mention natin to kanina, di ba? In accordance with the Commission's rules and regulations on electronic filing. Ito, na-mention natin to kanina na BP 96, BP 86 dapat to. Nasa previous corporation code natin, meron tayong section 13 which prescribes for the 25-25 rule at least 5,000 paid up capital. Ngayon, since tinanggal na yun siya. So, yung bagong section 13 natin, is this one, yung Contents of Articles of Incorporation. Now, itong Contents of Articles of Incorporation, dati to siya Section 14. Pero since tinanggal yung dating Section 13, nag-move up siya. Naging Section 13 na siya. Sana yung pumalit. Kasi tinanggal na. As in, tinanggal talaga yung dating Section 13, yung 25-25 rule. Hindi siya in-amend, tinanggal talaga siya. Kaya nag-move up yung numbering ng mga sections sa corporation code natin. So, ito dati, Section 14 to siya. Ngayon, 13 na. So, salient points. Ito. The revised Corp Code provides pursuant to Section 181, yung arbitration agreement may be provided in the AOI. Ito, this is ito later. Yung AOI and applications for amendments thereto may be filed with the SEC in the form of electronic documents in accordance with the rules on electronic filing. So, ito. Nagtutubig nga. Naglalaway ako. With the rules on electronic filing that the SEC will promulgate. So, ito innovations to. And, ito, ilang beses natin ito sinabi, the removal of treasurer affidavit. Ulitin natin, itong nasa treasurer affidavit is basically itong 25-25 rule and yung at least talk sa basically the treasurer certifying na na-follow yung 25-25 rule at least 5,000 paid up capital. Yun yung nakalagay sa sa treasurer's affidavit. But since tinanggal na tong 25-25 rule, parang wala nang purpose itong si treasurer affidavit. Yun. Ngayon, pinag-uusapan natin since last video pa, since title 1 pa, yung kahalagahan ng isang articles of incorporation. Ano nga ba ang isang article of incorporation? Na itong articles of incorporation is the document prepared by the person establishing a corporation and filed with the Securities and Exchange Commission containing the matters required by the code. So as you can see, similar yung nature niya sa articles of partnership natin. However, ito, for corporation to siya and is required by the code. Yung articles of incorporation, yung articles of partnership natin, basta may contract lang, goods na, may partnership ka na. Generally. Pero pagdating sa corporation, required kang maggawa ng isang articles of incorporation. Then, ipa-file mo to sa Securities and Exchange Commission together with the necessary documents required and hintayin mo kung i-approve yan para yung Securities and Exchange Commission mag-i-issue ng Certificate of Incorporation. Pag na-issue ng Certificate of Incorporation mo, then may legal existence na ang iyong corporation. Ganun kasimple ang process. It has been described as one that defines the charter of the corporation and the contractual relationship between the state and the corporation, the stockholders and the state, and between the corporation and the stockholders. Kasi nakalagay dyan sa Articles of Incorporation na yan, basically kung ano yung labot, ano yung nature, everything about the corporation itself. Dyan nakalagay. Nasa sa everything kasi may bylaws pa tayo pero later on na yun. But itong Articles of Incorporation, para siyang the governing rule of the corporation. Siya yung special charter. Yan yung charter niya eh. Oo, dyan nakalagay sa Articles of Incorporation. So, para mas ma-imagine nyo na properly, isipin nyo na lang, para rin siyang Articles of Partnership. Pero pang corporation lang. Applicable to corporation nga lang. So, a copy of the articles filed which is returned with a Certificate of Incorporation issued by the Commission under its official seal becomes its corporate charter, enabling the corporation to exist and function as such. So, ganyan kahalaga ang isang Articles of Incorporation. Kung gusto nyo, pwede kayong mag-search sa internet. Maraming samples dyan ng Articles of Incorporation, especially from the big companies. Ang dami dyan. Doon nakalagay yung mga contents nito. Necessary talaga yan for its existence and function. Kasi, yan yung ifa-file mo. Gaya ng sabi natin, yung ibibigay mo kay SEC. Para si SEC, i-approve niya. Mag-issue siya ng Certificate of Incorporation. Kung saan, may legal existence ang corporation mo. Now, a corporation created by special law has no Articles of Incorporation. Yes, di ba sabi natin kanina? Or last time pa. There are two ways to create a corporation here in the Philippines. The first one is through a general corporation law. In this case, the revised corporation code. Kung saan, kung sino man gustong mag-create ng corporation, follow lang nila yung general corporation law. Subject to the intervention and approval of the state, boom, may corporation na sila. The other way to create a corporation is through a special law. Kung saan, through that specific legislation, through that special law, magkakaroon ng special charter ang isang corporation. Yun, there are two ways to create that. To a general corporation law, and second, through a special law created, special charter. So, kung yung corporation na created by special law, wala siyang articles of incorporation. But rather, yung kanyang governing yung kanyang equivalent sa articles of incorporation is the special charter. Nakalagay mismo sa batas kung paano siya mag-ooperate. Kaya no need na ng articles of incorporation sa kanya. Nakalagay na mismo sa special charter niya. So yan, tandaan niya yan. Kasi yung general corporation law natin, in this case, the revised corp code, is formation of private corporations. Now, contents and form of the articles of incorporation. So I want to specify lang talaga na mahalaga itong articles of incorporation natin . This section enumerates the matters, mandatory provisions to. Ibig sabihin, you need to follow. You're compelled to follow them. That must be stated in the articles of incorporation of domestic corporations, except as otherwise prescribed by the code or by special law. Basically, ito yung minimum na kailangan mong ilagay kung ano yung nakalist doon. Unless, except otherwise, either dagdagan pa as prescribed by the code and or other special laws, lalo na pag mga special corporations like yung mga financial institutions like banking, insurance, yun, may mga special pa yun sila. Additional requirements pa yun sila. The incorporators may include such other matters that are not, as long as they are not inconsistent with law and which they may deem necessary and convenient. Nakalagay sa number 10, di ba? As such, the classes of shares in which the corporation may issue provisions on preemptive rights. Ito mga examples, like dagdagan nila yung classes of shares, specific classes, specific groups, yung provisions on preemptive right, later natin discuss yan. Yung contents ng articles of incorporation may be held valid as an agreement between the parties thereto, even though the validity of such may be subject to question. So, between parties, itong articles of incorporation, valid yan. Personal obligation nila yung sa isa't isa. Now, when it comes to its validity, it will be subject to question. Pag-aaralan pa yan ng state, ng government, in this case, the Securities and Exchange Commission, kung valid nga ba itong articles of incorporation na sinabit sa kanila for approval. So, yan . The articles of incorporation may provide other matters or items, optional provisions, as long as they are not contrary to any provisions of the code or special law. So basically, let's talk about yung last part ng last part nito, which is such other matters as long as it's not inconsistent with the law. Ito, name of the corporation. Ito, parang rin to . Same sa concept of discussion na ginawa natin sa partnership. Yung concept of discussion. Kung gaano siya kahalaga. Importance. Since the corporation acquires a juridical personality, ibig sabihin may siya pagkatao. Ano yung pagkatao? Kasi hindi man siya natural person. May personality na siya, kumbaga. Kailangan niya na ng pangalan. At yun ang ilalagay sa Certificate of Incorporation. Since may identity na siya binigyan na siya ng legal existence. So, kailangan bigyan mo ng pangalan yan para may talaga siya. May personality talaga siya. May identity ba siya? Kasi pag wala kang pangalan, wala kang identity. A corporation has the power of succession by its corporate name. It is the name of the corporation which is identified, distinguished, etc., etc. from other firms. Kasi iba-iba yan sila Pag wala yung pangalan, mahirap siya i-distinguish from other corporations. Yan yung corporation na. Hindi. Mahirap, diba? Kailangan, bigyan mo talaga ng pangalan. Etc. By its name, a corporation is authorized to transact business. The name of corporations, therefore, basically, this paragraph that states how important a name is in general. Oo. Because of this name, it can do transactions na as which is its purpose kumbaga, importance. Nature. Basahin nyo na lang, adoption, disregarded nature trademark, part of name, ito, it is customary to use as part of the name, corporation or incorporated, yung INC hindi Iglesia ni Cristo yung INC dot, yung Alidin El Habi, corporation or Alidin El Habi, comma, Inc. Yun. Or an abbreviation of, or ito, Alidin El Habi, Co. Dot. Yun. Makikita niyo, di ba, sa mga names ng mga corporations, or an abbreviation of either of them to distinguish it from partnership and other business organization para malaman kung corporation ba yan o partnership. Or baka sole proprietor lang. Or baka, tawag dito? Kasi pag cooperative siya, may co-op yan sa last, so may determination rin sila. Mas ma-distinguish rin sila. So yan, importante lagyan ng corporation or incorporated sa pangalan. But the character of a corporation is not necessarily controlled by name. So just because nakalagay na badass corporation, hindi ibig sabihin na badass yung the way patakbuhin yung corporation. So the character of the corporation is not necessarily controlled by its name. Badass corporation, yun pala, for foundation pala siya, no? Yun. Now, purpose or purposes of the corporation. Ito, mahalagang topic to. The purpose clause. Now, kung trip nyo lang, nag-search kayo ng mga articles of incorporation ng mga companies, lalo ng mga big companies, and basahin nyo, makikita nyo doon yung mga purposes ng mga companies na yun, para mas maintindihan nyo tong purpose clause. Kasi makikita nyo doon yung reason. Bakit na-form yung corporation. Like for example, kung sa Globe yan, to provide telecommunication services. Yan sila ni Globe PLDT. Yan, isa yan sa mga purposes nila. So, kung trip nyo lang, basa-basa, mag-search kayo, which will also be helpful sa inyo. Bakit? Kasi sabi ko, papagawan ko kayo ng mga necessary documents such as the Articles of Incorporation. Basically, gagawa kayo ng sarili nyong corporation. Gaya ng pinagawa ko kayo ng partnership. Yun. So, para ngayon, as early as na, ma-familiarize kayo kung anong itsura nun para makapili na kayo kung anong klaseng corporation ang gusto nyong patayuin. Baka banking ba yan? Public utilities? Your choice, your music. So, purpose clause, the clause in the Articles of Incorporation which states the specific purpose or purposes. Anong meaning yan? Ibig sabihin, pwede kang magkaroon ng more than one purpose para sa iyong corporation for which the corporation is being incorporated. Pwede more than one purpose, obviously. Sinabi na natin yan eh. Now, but meron tayong things to follow for this purpose. Oo, hindi ka lang basta-basta maglagay dyan ng purpose ng iyong corporation. You have guidelines. You have provisions to follow. Purpose or purposes must be lawful. A corporation may be organized only for any lawful purpose or purposes. Otherwise, no corporation may be created even though some of its declared purposes may be lawful. Oo, kasi nagsabit ka ng Articles of Incorporation. Lahat doon ng purposes mo is lawful maliban sa isa. Hindi yan pwede ma-amend ng SEC mismo na tanggalin natin to. Hindi. Pag primary purpose yan. Kailangan wala kang unlawful purposes. Kasi pag i-approve yan ng SEC, kalokohan yan, labagin sa batas. Kaya lahat dapat yan lawful. Para hindi i-reject ng SEC. Para hindi i-reject ng SEC, ng commission. So, parang common sense eh. Bakit ka mag-file ka ng Articles of Incorporation sa Securities and Exchange Commission for the subject for approval, tapos maglalagay ka ng unlawful purposes? Kalokohan, di ba? So, dapat it must be lawful. Now, purpose or purposes must not be indefinitely stated. Ibig sabihin, hindi dapat malabo. Hindi dapat na vague. Malabo. Hindi dapat vague yung purpose na nilagay mo sa iyong Articles of Incorporation. Bakit? Kasi kalokohan yan. The purpose or purposes stated in the Articles of Incorporation need not set out with particularity the multitude of activities in which the corporation may engage. The effect of broad purpose or objects is to confer the wide discretionary authority upon the directors and management of the corporation as to the kinds of business in which it may engage. Dealings which are entirely irrelevant to the purpose or are unauthorized and called ultra vires act. So, anong meaning yan? Ganito lang yan. Dapat hindi ka vague sa iyong purposes. Kasi kung vague ka sa iyong purposes, it will mean na marami kang pwedeng gawin. Oo, yung sakop ng ng mga things na pwede mong gawin, masyado malaki. Hindi yan. Hindi pwede ganon. And at the same time, hindi ka pwede masyadong particular. Hindi ka pwede masyadong specific. Because you're basically subjecting yourself to limitations on how you will perform your business. Oo. So, dalawa yan. Hindi ka pwede maging vague. Hindi ka pwede maging napaka-specific. Dapat sakto lang. Ang tawag dyan, sufficient clarity. Oo. Not too much, but not less. Sakto lang. Enough for the enough para sa director and management of the corporation to do kinds of business para or in which it may engage. Oo. Kapag dealings which are entirely irrelevant to the purpose are unauthorized and ultra vires acts ang tawag dyan. Ito, ultra vires acts, ilang beses ito maririnig sa Articles of Incorporation. Basically, itong meaning ng ultra vires acts, these are acts na ginawa mo, pero wala ka namang karapatang gawin. Either it is not within the purpose of the corporation or labag yan sa batas. Yan yung ultra vires acts. Acts that are performed even though you have no right over that, or acts that are performed that is unlawful. Ultra vires acts. Yan, lalabas yan sa lalabas yan sa board exam, itong ultra vires acts. So yan basically itong meaning nito, hindi dapat vague, hindi dapat too specific, sakto lang, sufficient clarity. Para at least there's enough room for the directors and management of the corporation para may wiggle room ba in doing business, transacting business for the corporation. Sufficient clarity yung tawag dyan. Primary purpose must be stated. Now, as we have said, a corporation may have more than one purposes, di ba? More than one purpose. More than one purposes. More than one purpose ang tama, no? The purposes for which a corporation is organized where it has more than one stated purpose shall state which is the primary or main purpose and which are secondary or subsidiary purpose or purposes. Ito mas maintindihan nyo to pag gaya ng sabi ko, pag may binasa kayong Articles of Incorporation, lalo na yung mga kilalang companies, yung alam nyo kung anong ginagawa nila. Like for example, sa PLDT, sa Globe, I think nung college ako, di ba sinabi ko sa inyo, na pinagawan kami ng corporation, but the only difference sa atin, handwritten yun sa amin. Sa inyo, hindi ko kayo papa-handwritten. Yung pinili ko atang, corporation sa akin is either PLDT yata yun or Globe. Oo, yun yung pinili ko. Telecommunication. So, kung magbabasa kayo, titingnan nyo. Makikita nyo talaga, stated doon, alin yung primary purpose and alin yung secondary purpose. Pag binasa nyo, makikita nyo talaga yung difference nila. Oo. Maganda talaga if mabasa nyo. Para mas maintindihan nyo yung difference ng primary and secondary purposes. But, from the name itself, obvious naman alin yung primary, alin yung secondary purpose. Purposes must be capable of being lawfully combined, meaning, meaning, kung banking ka, example, kung banking ka, hindi ka pwedeng mag non-banking activities such as insurance. Kapag insurance ka naman ng corporation mo, hindi ka pwedeng mag-engage in banking corporations. Na ito, must be lawfully combined, parang may specific provisions sa mga batas So, special laws na yan. But, basically, check mo na kapag magko-combine ka ng purposes, make sure na hindi ito labag sa batas. Like ito, examples natin. Na ito naman, pinag-usapan natin yung primary and secondary purposes. Like for example, primary purposes. Primary purpose ng isang corporation. Like say, telecommunication yan. So, since telecommunication yan, anong mga ginagawa ng isang telecommunication company? Magtayo ng cell site, maglatag ng fiber optic sa daan. Oo, yun. Maglatag ng fiber optic sa daan. Primary purpose yun. Secondary purpose, ano? Ano magandang secondary purpose? Ayun, secondary purpose. Magtayo ng ng substation. O yun, maglagay sila. Magtatayo sila ng substation in one of their main facilities to support the operations. Yun, secondary purpose yun. So, itong primary purpose and secondary purpose, depende yan sa kung anong corporation meron. Kanya-kanya yan. Depende sa kung ano yung gagawin nila. Ano yung business nila. Now, so ito, what are the reasons for statement of purpose or purposes? The law requires the statement of purpose or purposes for which a corporation is formed in order that the person who intends to invest his money in the business of the corporation will know kung ano ba yung kind of business or activity na gagawin ng corporation kung saan ininvest niya yung kanyang pera. Of course, kailangan alam niya ng investor, hindi pwede basta-basta mag-invest. Dapat alam niya, ito parang corporation na pag-invest ko ng pera ko. Ito pala yung kanyang activities eh. Telecommunication pala siya. Construction pala siya. Banking pala siya. Para klaro. Another reason is for the directors and officers of the corporation will know within the scope of business they are authorized to act. Kasi pag sila, nag-over ano yung proper term? Nag-overscamp? Hindi. Parang sumobra ba sila? Parang pag sumobra sila sa acts nila, sa authorized act, then ang tawag doon, ultra vires. Diba? Sabi natin? Oo. Kaya dapat stated kung ano yung purpose or purposes ng corporation para alam ng mga nagmamanage ng corporation, the directors and the management, kung ano yung mga pwede nilang gawin para hindi sila mag-commit ng ultra vires acts. Yan, isa yun sa mga reasons. Pangatlong reason is a third person who has dealings with the corporation may know by perusal of the articles whether the transaction or dealing he has with the corporation is within the authority of the corporation or not. Like for example, banking corporation. Siyempre, yung third party, dapat alam niya na hindi pwede mag-directly engage yung banking corporation sa isang insurance business. Hindi siya pwede directly. So, para malaman niya yun, titingnan niya yung articles of incorporation niya kung ano yung mga purposes. Oo. Or construction company. Ang construction company, di may taga-benta ng mga equipments. So, titingnan niya ng third persons. Nagbibenta ba ito ng equipments? Di man, construction company man to. So, yan, mahalaga yan. Para sa investors, para sa directors, and para sa third persons engaging or transacting with the corporation. Sorry, kanina pa ako binabother ng mais sa ngipin ko. In other words, the main reason for stating the purpose of the corporation is to determine whether the acts performed by the corporation are authorized or beyond its power. Beyond. Naalala ko na yung over-encompassing and beyond. When it is beyond its power, when it is over-encompassing, then it is an ultra vires act. May limitations yan. Yun, naalala ko na yun. In the latter case, they will be known as ultra vires acts. When it is beyond their authorized act, beyond their authority, beyond their powers, over-encompassing. Ultra vires na yan. Thus, the purpose clause of the Articles of Incorporation indicates the extent as well as the limitations of the powers which a corporation may exercise. Now, ano na mangyayari kapag yung primary mo and or yung secondary mo purposes is unauthorized? Bawal. Kapag primary purpose yung unlawful, walang legal existence yung corporation. Wala yan. However, kapag yung secondary purpose yung unlawful, then this additional and authorized assumption may be treated as surplusage, and the corporation regarded as entitled to exercise the lawful powers only. So, pag primary purpose, wala talagang legal existence. Kapag secondary purpose lang yung unlawful, pwede mong i-chapwera yung secondary, you can continue with the corporation. But it can only exercise the lawful powers. So, i-disregard mo lang yung secondary purpose unlawful. Ito, simple na lang. Places where principal office of corporation, city or municipality within the Philippines, mas stated in the, sa articles of incorporation, kung saan yung principal office to be established, located, which must be a place within the Philippines. Of course, it is a Filipino corporation. Dapat sa Philippine yung office yan. Fix the residence para di lagan. Para alam ba kung saan yung office, kung saan pupuntahan. Yan yung main reason bakit pinapalagay ng batas natin sa ating articles of incorporation yung address, yung location ng principal office ng corporation. Now, it is now required by the Securities Exchange Commission that all corporations and partnerships applying the registration So, sorry for the interruption. Kung narinig nyo kanina, di ba? Ting ng cellphone ko. Kala ko emergency. Yun pala, may nagtatanong lang. Ting. Tapos marami pala nag-chat. Yawa. Anyways, let's continue. It is now required by the Securities Exchange Commission. Wala tuloy ako sa flow ko. It is now required by the Securities Exchange Commission that all corporations and partnerships applying for registration should state in their AOI or AOP the following: specific address, principal office, visible, mas specific. Place where its books and records are ordinarily kept and kung saan hiniheld yung meetings. Itong meetings na to, meron tong specific provisions later on, malalaman nyo. Kung pwede magkaroon ng board meeting sa ibang bansa, pwede 'yun. Pero pag board meeting, pero pag stockholders, Pinas lang 'yan. Change of address, inform or i-notify yung SEC kung magkakaroon ng change of address. So, napakasimple. Place where principal office or corporation located. Ito naman. Incorporating directors or trustees. Now, di ba may tatawag tayong incorporators? Sila yung yung mga pangalan nila nasa Articles of Incorporation. Sila yung mismo yung pasimuno. Oo, sila yung kauna-unahan, kumbaga. For the directors and trustees, meron rin tayo. Oo, incorporating director or trustees. Ibig sabihin yung pangalan nila nasa Articles of Incorporation. Ibig sabihin sila yung nauna. Sila yung ninuno, kumbaga. From the very start sila. Now, the incorporating directors or trustees are those chosen by the incorporators and named in the Articles of Incorporation. So, the term trustees is used to refer sa members ng board ng isang non-stock. So, ang directors sa stock corporation siyan. Now, matters to be specified sa Articles of Incorporation, yung AOI must specify the names, nationalities, and residences of the incorporators and must show that at least a majority of the incorporators are resident of the Philippines. Because that will show a prima facie compliance with constitutional legal requirements of Filipino ownership. Itong prima facie, alam ko familiar na kayo sa term na to, sa obligation and contraction pa lang. But basically, ang meaning ng prima facie is at face value. Sa unang tingin, yun yung meaning ng prima facie. Sa unang tingin, there's proper compliance with the constitutional or legal requirement when it comes to the minimum Filipino ownership. Yun ang prima facie. Sa unang tingin pa lang. Number of incorporating directors, di ba? Incorporating director, ang sabi, not more than 15. Pagdating sa trustees, pwede kang lumampas ng 15. Term of office shall hold on office until their successors are duly elected and qualified. Later discussion natin yan when it comes to election of directors. And they must be subscriber of the stock. Ito, talking about stock, the stock, capital and subscribers, contributors. For the stock corporation, the articles of incorporation of the stock corporation under this section must state the following: amount of authorized capital stocks in peso, number of shares, par value, original subscriber, amount of stock subscribed and paid by each subscription, and in some of those cases, without par value, shall state shots fact, fact, fact. Yun parang basahin nyo lang to. Basic na lang, oh. Amount capital, no sweat, di ba? Basahin na lang. Ito, arbitration agreement. Itong arbitration agreement, it is an innovation dito sa revised Corp of the revised Corp Code. Dati wala to. Basically, itong arbitration agreement is a way of resolving a dispute without filing a suit or going to court. Ibig sabihin, extrajudicial to. Extrajudicial negotiation, extrajudicial agreement. Meaning ng extrajudicial, outside of court. Pag judicial, sa court na yan. The arbitration process is similar to the proceedings in a court case. The parties may have lawyers, they exchange information, and there is hearing where they question witnesses and present their cases. After the hearing, the arbitrator will make a decision. So, yun. Yun ang ilalagay nila sa arbitration agreement. Ang sabi sa batas, pwedeng maging basis ng ating or ng isang articles of incorporation ang arbitration agreement. Kasi dyan pinag-usapan nila yan. Agreement yan nila. Yun lang, additional innovation lang yan ng ating articles of ng ating revised Corp Code. So, yan, arbitration agreement. So, yan, arbitration, paano ba sila? Arbiter. Oo, si arbiter, arbitrator, magkakaroon sila ng agreement. Sa anong kasunduan nila. Ito. Let's go to section 14. Itong section 14, it provides for the form of articles of incorporation. Unless otherwise prescribed by special law, the articles of incorporation of all domestic corporations shall comply substantially with the following form, sige, tingnan natin Ayaw mag-exit. Ito ang itsura niyan. Diba? Sinend ko na itong document na to. Ito ang forms of article of incorporation. Now, ito yung itsura niyan. Unless otherwise prescribed, lalagay nyo articles of incorporation, dito names of corporation. Ito, the undersigned incorporators, legal aids, stock, non-stock, etc. Following. First, the name of said corporation shall be Now, para mas maging klaro to tingnan sa para mas maging klaro to sa inyo, gaya na sabi ko kanina, you can look sa internet. Marami talagang sample doon ng articles of incorporation, especially from the big companies. Like sa akin, ang ginamit ko is PLDT and or Globe ata yun. Basta either, kinombine ko yun sa silang dalawa nung gumawa ako ng corporation para sa project namin nung college ako. Kinombine ko sila. Telecommunication yung pinili ko. So kayo, anong pipiliin nyo? Ito, the principal office, dito second yung purposes, o kung primary man yan or secondary, ito, hahaba yung mo. Dito sa second part, hahaba yung articles of incorporation kasi you will state many purposes. Oo, guaranteed yan. The corporation shall have perpetual existence or a term of kapag gusto nyo lagyan ng fixed term. Ito naman yung nationalities, residence address ng mga incorporators. Ito sa 6, yung directors, numbers nila. Dito, ililista mo, nationality, residence. 7 naman, ito, nilagay ko mga name ng classmates ko for the incorporators and the directors. Ito, 7, yung about sa capital stock. Ito, about sa share, yung sa subscription. Ito sa treasurer, etc., etc. Witness thereof, yun. Tapos ipasign nyo pa yan. Sasabihin ko na sa inyo, ipapasign nyo pa yan dito sa baba. So yan ang itsura ng isang articles of incorporation, isa yan sa mga gagawin nyo sa iyong project. So yan. Yan simple lang, di ba? Now ito, salient changes lang. Pursuant to the provisions of the one-person corporation, sa revised corp code natin, a corporation should indicate in its AOI na ito ay isang one-person corporation. Treasurer certifies the receipt of cash or property in the body of the articles of incorporation in lieu of treasurer's affidavit. So, dyan napunta yung treasurer's affidavit. Hindi na sa separate document, but rather, saan yun? Dito na. Si treasurer mag-sign dito sa baba. Pero wala ng 25-25 rule, wala ng 5,000 paid capital. And yung treasurer's affidavit, tinanggal. Kinombine na lang dito. May certification na dito, no? Mag-paperma si treasurer. Ito, revisions ng article, revisions. The number of trustees indicated in the articles of incorporation may, ito, mention natin kanina, more than 15. Yung directors, up to 15 lang. Pero trustees, more than 15. Filing ng articles of incorporation and yung amendments na pwede na electronically as provided under the guidelines of the Securities and Exchange Commission. Yung authorized capital stock no longer needs to be 25% subscribed, yung 25-25 rule. Treasurer's affidavit is no longer required since the certification concerning the amount of capital subscribed or paid is already included sa articles of incorporation. So yun, isa yun sa mga reason bakit wala na ang treasurer's affidavit. Kasi sa treasurer's affidavit, basically, mini-mention dun is yung authorized capital stock, ilan yung subscribe, ilan yung paid, and the treasurer will certify that sa kanyang affidavit. But since tinanggal na yung 25-25 rule, wala nang halos ilalagay doon si treasurer. So, i-incorporate na lang yan sa articles of incorporation kung saan doon na magsi-certify mismo si treasurer na ito yung authorized capital stock. And ilan yung mga There's no minimum paid up capital. This time, as compared to the previous corp code, this time, properly followed na siya. Kasi wala na yung 25-25 rule. Innovations, arbitration agreement may now be provided in the articles of incorporation. Kung anong pinagkasunduan nila, pwede nilang ilagay yan sa articles of incorporation. One-person corporation must bear OPC at the end of its corporate name. The forms of the articles of incorporation. So, yan ang ating section 14. Basically provides for the form of the articles of incorporation. At the very least, kung may needed pa as provided by the code or other special laws, then gagawin yon. So ito, mga important notes na lang tayong didiscuss natin kasi kung babasahin nyo to, easily understandable siya. So let's go to section 15. Now, section 15 provides for the amendment of the articles of incorporation. As we have said kanina, yes, the people in the corporation can amend the AOI. Oo, pero mag-submit yan sila sa SEC for approval ng amendment. Now, Section 15 provides that unless otherwise prescribed by this code or by special law, and for legitimate purposes only, any provision or matter stated sa Articles of Incorporation may be amended by take note of this, lumalabas sa board exam, may be amended by a majority vote of the Board of Directors or Trustee and votes or written assent of the stockholders representing at least 2/3 of the outstanding capital stock. Tandaan yan. Majority ng board and ng board and 2/3 ng board of ng stockholders representing at least 2/3 ng outstanding capital. Yun ang required votes para ma-properly amend yung corporation without prejudice to the appraisal right of the dissenting stockholder in accordance with the provisions of this code. Ito, na-discuss natin to si dissenting stockholder. Ulitin natin. Kapag yung amendment dito will adversely affect these dissenting stockholders, then they can file for withdraw. Pwede silang mag-withdraw sa corporation. Then, yung ibabayad sa kanila for their shares, for their stock will be the fair value. Yun yung appraisal right. I-appraise yung kanilang stocks para yung fair value nito, yun yung ibabayad sa kanila. Kasi yan yung ang dissenting stockholder pag nag-disagree sila sa kung ano yung ibabago sa corporation, sa changes sa corporation. So, since hindi nag-disagree sila, then wala nang ibang way, so kailangan na nilang mag-withdraw. Dissenting nga eh. The articles of incorporation of a non-stock corporation may be amended by a majority by the vote or written assent of the majority of trustees and at least 2/3 of the members. Now, as you can see here, may napansin kayo. Ano yun? Ito, mini-min nito, 2/3 of the, representing 2/3 out of the outstanding capital stock. So, hindi to per head. Oo. Hindi to per head. Based on ownership interest to. Dapat 2/3 of the outstanding capital stock. Pagdating dito, per head. Kasi 2/3 of the members. Tandaan niyo na. Sa Board of Directors and Trustees, or Board of Director and Trustees, or Trustees, per head yan. Pagdating sa, sa stockholders, hindi na yung per head. Based na yun sa ownership interest. Dapat at least 2/3 ng outstanding capital stock. Tandaan nyo, anong outstanding capital stock? Ito yung na-issue na. Na-issue ng corporation na may ownership na, paid na. Pagdating naman sa non-stock corporation, hindi per head yung bilangan. Okay, tandaan nyo yan. The original and amended articles together shall contain all provisions required by law to be set out in the articles of incorporation. Of course, required by law mandatory yan. Amendments to the articles shall be indicated by underscoring the change or changes made and a copy thereof duly certified under oath by the corporate secretary and a majority of the directors or trustee with a statement that the amendments have been duly approved by the required vote of stockholders or member and it shall be submitted sa commission. So, before yan, isasubmit sa commission, dapat may voting muna ng approval. The amendment shall take effect upon their approval by the commission or from the date of filing with the said commission if not acted upon within 6 months. So, pag wala pang ginawa si SEC, after 6 months, approved na yan. Automatic. Pag walang ginawang action si SEC. And by SEC, I mean commission. Para dito filing for a cost not attributable to the corporation. Powers of stockholders to amend, powers of the members or stockholders to amend the articles of incorporation. The authority of stockholders or members to amend the articles of incorporation which form part of the corporate charter, such as the extension or shortening of corporate term. Ito samples ng mga pwedeng i-amend sa corporation. Sa articles of incorporation. Yung extension or shortening ng corporate term, increase or decrease sa capital stock, yung authorized capital stock, and two amendments in general, to matters other than the foregoing, including the change in corporate name. Kung ano yung nakalagay sa articles of incorporation, amendment. Kaya nga, amendment of articles of incorporation. Now, take note, sa bylaws, pwede rin magkaroon ng amendment. Pero later natin i-discuss yun. Kasi for this title 2, we're only talking about the articles of incorporation. The power to amend is also expressly granted by the code. The amendment must be approved by the board of directors or trustees. So, kasi basically this only talks about the power of the stockholders members. Of course, dapat may approval rin yan ng board of directors or trustees. So, yan, power lang yun nila. Basically explaining. Now, necessity of stockholder or members meeting for amendment. Ngayon, if we're going back to this, you can see na ginamit yung written assent. Written assent. And the vote or written assent. Pagdating sa board of directors or trustees, kailangan ng vote. Pagdating sa sa stockholders or sa members, vote or written assent. Vote or written assent. Take note of that. Why? Written assent. The amendment may also be effected by the written assent. Pwede lang magpadala sila ng letter nila. Of the stockholders representing at least 2/3 of the outstanding capital stock of the corporation or 2/3 of its members. Meaning that such action need not to be taken in a meeting and upon a vote. Even holders of the non-voting shares or non-voting members, as the case may be, di ba? Yung exceptions, basically, generally hindi sila nagba-vote, pero may mga exceptions, di ba? Provide natin sa Title 1. Are entitled to vote on the amendment. Meaning, hindi na kailangan nila mag-held na meeting. Pwede na sila magpadala ng letter nila o hindi na sila kailangan mag-attend pa sa meeting. Padala nila ng letter nila kung nag-agree ba sila sa changes, sa amendments or hindi. Written assent. Now, if the amendment consists in extending or shortening the corporate term or increasing or decreasing capital stock, then tsaka kailangan ng meeting ng stockholders or members. Oo. Hindi lang pwede basta written assent. Kailangan nasa meeting sila. In a closed corporation, the amendment of Articles of Corporation refers to any of the matters mentioned in this code. Later, discuss natin closed corporation. The same shall not be valid or effective unless approved by the required vote of the stockholders at a meeting duly called for the purpose. Yun, special yan. Pagdating sa closed corporation, kailangan mag-attend ng meeting and may required approval of vote. A mere written assent would also be sufficient. In cases where written assent is allowed, the same number of votes shall be observed and nothing can be done by proxy. Etong closed corporation, di-discuss natin to later on. Kasi, as opposed to open corporation, itong closed corporation nga siya, pero tightly held siya. Usually, magkakamag-anak mga yan. Magkakamag-anak ang mga yan, and hindi siya publicly traded. Closed corporation. Kaya may special rules may special regulations pagdating sa closed corporation because of how tightly it is. How very close, kumbaga. Now, ito, limitations on power of corporation to amend. Ito, tawag dito, understand mo, as long as not as against the code or special law, legitimate purposes, approved by the directors and stockholders, required vote, original articles must contain all provisions required by law, underscoring, take off 6 months, sabi natin to. Ito, if a corporation is governed by special law, such as banks, banking and quasi-banking institutions, insurance, etc., they must be accompanied by the favorable recommendation of the appropriate government agency of the effects that such amendment are in accordance with the law. Ito naman, pagdating sa cases ng foreign corporation, sir, pwede mag-operate dito ang foreign corporation sa Pilipinas? Oo, pwede yan sila mag-operate dito. Didiscuss natin ito sila later, sa later sections. Kailangan lang nila ng approval from the SEC, from the government, para mag-operate sila dito sa Pilipinas. Pero didiscuss natin to. Pero later on pa yun. In the case of foreign corporations authorized to transact business in the Philippines, they are merely required to file within 60 days after the amendment to the Articles of Incorporation or bylaws becomes effective with the Commission, and in proper cases where with the appropriate government agency adjudicating Articles of Incorporation or kung bylaws man yung in-amend nila for record purposes. Tandaan nyo, for record purposes. Kasi ang mag-approve niyan yung commission sa bansa nila. Dito sa Pinas, it is only for record purposes. The filing thereof, however, shall not of itself enlarge or alter the purpose of corporation is authorized under this license to transact business, such person, etc., etc. So yan lang. Napakasimple ng amendment napakasimple ng topic ng amendments ng Articles of Incorporation. Ang tatandaan nyo lang dito is yung number of votes. Oo, yung ilang votes. Board of Directors, Board of Trustees, majority. Required yan sila na sa meeting. Pagdating sa stockholders, hindi yan per head. Based yan sa ownership. 2/3 of the outstanding capital stock. Pagdating sa members, per head yan. 2/3. Written assent. Kahit hindi sila pumunta sa meeting, padala lang nila letter nila. Goods na. However, there are certain instances kung saan kailangan present ang mga stockholders and or members na to. Like increasing or decreasing the capital stock, shortening or extending the corporate term. Yan. Pagdating sa closed corporation, kailangan sila magpakita. Hindi lang enough yung written assent. To limitations, yan lang. Ganyan lang kasimple si amendment of Articles of Incorporation. Ang important point lang dito is yung lumalabas na sa board exam. Number of votes. Now, let's go to Article 16, Section 16, Ito, we have talked about the amendments. Now, let's talk about the grounds when Articles of Incorporation or amendment may be disapproved. So pinag-usapan natin, 'di ba, yung filing ng articles of incorporation sa commission and yung pag-file ng amendments para sa kanya. Now, there are instances na pwede ma-disapprove ng commission. This is governed by Section 16. The commission may disapprove the articles of incorporation or the amendments thereto if the same is not compliant with the requirements of the Revised Corporation Code of the Philippines. Provided, of course, that the commission shall give the incorporators, directors, trustees, or officers a reasonable time, of course, from receipt of the disapproval within which to modify the objectionable persons of the articles or the amendment. So yan, may kapangyarihan si commission na i-disapprove yung pag-file ng articles of incorporation, yung pag-file ng amendment, kapag it is not compliant with the requirements of the code and other special laws. Like yung wala silang favorable recommendation, which is also under the code naman eh. Provided na kapag na-determine ng commission na meron palang problema or error sa kanilang filing, inform nila yan sa stakeholders sa gustong mag-incorporate ng corporation para ma-modify nila yung objectionable portions. Bigyan ng chance, of course. Now, the following are the grounds for such disapproval. Ito yung mga grounds. Una, the articles of incorporation or any amendment thereto is not substantially in accordance with the form prescribed therein. Hindi daw nang-follow ng form substantially. Pangalawa, the purpose or purposes of the corporation are patently unconstitutional. Bawal. Labag sa constitution natin. Illegal. Immoral. Contrary to government rules and regulation. Basically, bawal sa labas. Labag sa batas. Pangalawa, the certification concerning the amount of capital stock subscribed and or paid is false. False misrepresentation ang tawag dyan. The required percentage of Filipino ownership, the capital stock under existing law or the Constitution has not been complied with. Yung mga, di ba yung sa list kanina, kung ilang percentage at the very least ang Filipino ownership. No articles of incorporation or amendment to the articles of banks, banking, quasi-banking, etc., other financial intermediaries shall be approved by the commission unless accompanied by favorable, sabi natin kanina, favorable recommendation of the appropriate government agency to the effect that such articles or amendments thereto amendment is in accordance with the law. Now, ito salient points, remarks. Basically, the changes that had happened as compared to the previous code. The specific inclusion of the NLAS. Na-mention nito sa previous sections. And pawn shops to obtain endorsement of favorable recommendations from the regulatory agencies prior to approval by the SEC of their articles of incorporation. Removal of the public utilities and educational institutions, prior endorsement or favorable recommendations from the regulatory agency prior to approval of the SEC. So, itong si NLAS and pawn shop, pinalitan nila si public utilities and educational institutions, tinanggal to. Previous code, nandito included to. Pero tinanggal na, pinalitan ng NLAS, NSLAS, and ng pawn shops. Specific change from treasurer's affidavit to certification, ito na-mention natin kanina, tinanggal yung treasurer affidavit, yung certification, doon na mismo sa articles of incorporation. Now, revision. Full certification concerning the amount of capital subscribed and or paid is a new ground to disapprove articles of incorporation or amendments thereto. Ito. Now, suspension or revocation. Suspension or revocation of certificate of registration of corporation. Ito. Ibig sabihin, yung certificate of yung certificate ng yung registration ng corporation was approved na. But later on, pwede yang masuspend or ma-revoke mismo, bawiin ng SEC, ng commission. Pwede. Ito yung mga grounds kung saan pwede yang isuspend, pwede yang i-revoke ng commission. And it is granted by presidential decree 902-A. The Securities and Exchange Commissions may suspend or revoke, after proper notice and hearing, the franchise or certification of registration of corporations, partnership, or association upon any grounds provided by law, including the following. Ito, fraud in procuring the certificate of incorporation, serious misrepresentation, refusal to comply or defiance of the lawful order of the SEC, continues in operation for a period of at least 5 years, failure to file the bylaws. Yes, itong bylaws, pwede nyo itong i-file later on. Kahit na dalawa yung ways para i-file, dalawa yung instances na pwede nyo i-file yung bylaws. The first one would be at the same time as the filing of the Articles of Incorporation. The second one would be after 1 month ng pag-file ng Articles of Incorporation. Oo, pwede nyo mag-file ng bylaws. Pero di-discuss natin ito later on. Failure to file required reports. Basically, pag hindi mo finalo yung rules and regulations provided by the law and other supplementary provisions, pwede yang ma-suspend or ma-revoke ng Securities Exchange Commission yung registration ng isang corporation, partnership, or association. Effectivity, subject, yung revocation is immediately effective. The entity, the corporation, the partnership, or the association may not continue to operate business and issue shares. Ngayon, of course, pwede naman yung bawiin ng corporation yung revocation. The lifting restores the corporation to its original status as if there was no revocation at all. Or there was no revocation at all na in-issue against sa kanya. With the capacity to exercise all the powers or of a duly registered corporation under the Corporation Code. So yan. Napaka-basic ni, di ba? Ni Section 15 at ni Section 16. Basahin mo lang, it is understandable naman. Kasi si Section 15, basically, it only prescribes about sa concept ng amendments ng Articles of Incorporation. Ilang votes ang kailangan? Power nito. Di ba? Sa Article 16, basically provides ano yung mga grounds para i-disapprove, i-reject ng commission yung pag-file ng Articles of Incorporation or ng amendments nito ng corporation. Ito, let's go with Section 17. Section 17. Section 17 basically talks about the corporate name, yung anong pangalan ang gagamitin ng corporation sa kanyang pag-ooperate, sa kanyang transactions, basically pag mayroon na siyang legal existence. Now, Section 17 provides that no corporate name shall be allowed by the Commission if it is not distinguishable from that already reserved or registered by the use of another corporation, or if such name is already protected by law, or when it is contrary to existing laws, rules, and regulations. As you can see here, already reserved or registered already. Na-mention natin, di ba, last time, yung already reserved, na pwedeng mag-submit ng pang-reserve, ng reservation. Pwedeng mag-submit ng reservation sa SEC prior sa application ng Articles of Incorporation. Oo, kaya nakalagay dito, already reserved. Para that time pa lang, ma-determine na ng commission kung may gumagamit na ba or kung may similarities na ba yung sinubmit na pangalan for reservation. Para earlier pa lang, ma-notify na yung mga gustong mag-file ng kanilang EOI na, meron na palang meron na palang similar name dito sa sinubmit yung corporate name for reservation. So, paki-modify na lang. Yun. Kaya nakalagay dito, already reserved or registered. Now, a name is not distinguishable. But take note yung pangalan, yung corporate name must be distinguishable. Ibig sabihin, dapat ma-determine mo na, ito, pag mention ng pangalan na to, itong corporation na to. Dapat hindi siya similar sa iba na kung saan mahirapan na kayong mag-distinguish. Ngayon, a name is not distinguishable even if it contains one or more of the following. Take note. Sabi dito, kahit na it contains the word corporation, company, incorporated, limited, abbreviation, limited words, punctuations, articles, injunctions, contractions, prepositions, abbreviations, different tense, spacing, number, same word, etc. Even though that name contains this following. Kapag hindi pa rin siya distinguishable, useless. And it cannot be considered as distinguishable even though merong mga ganitong names. Tandaan niya. Ulitin natin, even though may mga ganito sa pangalan, sa corporate name, hindi ibig sabihin distinguishable na siya. Hindi ibig sabihin na madaling ma-determine. Na separate siya sa iba. Hindi. Tinitingnan niya ng commission holistically, overall. Na, di ba may case yun, if you can still remember, may gumamit ng similar name sa Jollibee. Oo, may gumamit ng similar name sa Jollibee. Kinasuhan ng Jollibee. Kalimutan ko ano yung name ng kinasuhan nila. Pero natalo sila. Bakit? Ang sabi ng korte, kahit na medyo similar yung name nyo, pero iba yung industry nyo, wala pa rin. So, case-to-case basis yan eh. Case-to-case basis yan. Kaya nga sinabi ko, overall yung pagtingin ng commission dyan. Kung distinguishable ba from other names of the other corporations and other entities or protected by law or contrary to existing law, yun, titingnan yan. Pagdating dito, mas malalaman nyo tong topic na to pag na-discuss na sa inyong intellectual property law. Oo, mas maintindihan nyo tong corporate concept ng corporate name. Pag na-discuss na sa inyong intellectual property law, like may mga certain provisions talaga yan. Like dito, names already protected by law. Yung mga heroes natin, yung mga past presidents. Yan, if I remember correctly lang, sa seminar namin sa intellectual property rights, intellectual property law, hindi mo sila pwedeng gamitin na pangalan sa iyong business. Oo, stricto yan pagdating dyan. Isa yan sa mga names already protected by law, not contrary to existing laws. So, additional notes lang yan. Now, the commission, upon determination. Ay, dami nag-chat. The commission, upon determination that the corporate name is first, not distinguishable from a name already reserved or registered for the use of another corporation, already protected by law, or contrary to law, rules, and regulations, the commission may summarily, ibig sabihin, mabilisang process. Ang meaning ng mga summary proceedings, mga summarily, mabilisang process yan. Meaning yan, mga summary proceedings, may summarily order the corporation to immediately cease and desist from using such name and require the corporation to register a new one. Pag na-determine itong tatlo. The commission shall also cause the removal of all visible signages, marks, advertisements, labels, prints, and other effects bearing such corporate name. Upon the approval of the new corporate name, the commission shall issue a certificate of incorporation under the amended name. Now, if a corporation fails to comply with the commission's order, the commission may hold the corporation and its responsible directors or officers in contempt. Kasi and hold them liable and or hold them administratively, civilly, and or criminally liable under this code and other applicable laws and revoke the registration of the corporation. Anong meaning yan? Kapag matigas yung ulo ng mga responsible directors and officers ng corporation, pwede silang habulin, pwede silang kasuhan. Administratively man, civilly, or criminally. Ito, makatakot dyan yung criminal kasi pwede sila makulong. Like, example, nilabag nila yung provisions ng intellectual property rights o intellectual property law when using trademarks, when using names, and other applicable laws. Minsan nagiging criminally liable yan sila, lalo na pag may fraud, may bad faith, lagot yan. So yan, take note of that. So, Section 17 basically talks about the name of the corporation. Mas maganda itong ma-discuss. Ang supplementary ang supplementary provisions ito pagdating sa intellectual property law. Sana ma-seminar yan sa inyo ng JP. Ngayon, ito yung salient points or remarks, changes made from the previous corporation code, BP 68. Yung revised corp code natin ngayon includes some more detailed guidelines and requirements as to the corporate name. Tingnan nyo. Dami kong sinabing dami. Basta tingnan nyo. Pag may copies kayo ng old corp code ng BP 68 kasi before BP 68, meron din tayong Corp Code. Kasi nung pinag-aaralan pa namin yung additional note lang. Nung dinidiscuss pa sa amin yung BP68, itong BP68 ang tawag doon New Corporation Code of the Philippines. When we refer to the previous code, we call it the old code. Pagdating dito sa revised Corp Code, parang ganun rin yung scenario. We refer to BP68 as the old code. So, kung may copy kayo ng old code, BP68, yan, makikita nyo, mas stringent, mas stricto yung provisions ng Section 17 when it comes to corporate name. Kaya sinabi dito, it has more detailed guidelines and requirements. The new revised Corp Code have stricter rules on the use of the corporate names. The SEC, the Commission, is granted the authority to order a corporation to immediately cease and desist from using a name found to be not distinguishable. Ang pag-determine ng distinguishable, overall yan. Oo, case-to-case basis. Already protected by law or contrary to law as well as to cause the removal of all visible signages bearing such name. Tandaan nyo itong tatlo. Not distinguishable, already protected, contrary to law and regulations. Pagdating sa corporate name, tandaan nyo yung tatlo. Ito naman yung innovations. Rules on distinguishability of corporate names are provided. Ganito, just because the corporate name has these following words, following rules, does that mean na automatic distinguishable na siya. SEC has now the authority to cause the removal of all visible signages, marks, advertisement, etc., etc. Provided here. And lastly, failure to comply with the SEC's order related to disallowed corporate name may hold the corporation and its responsible directors or officers in contempt and hold them administratively, legally or criminally liable, and or revoke the registration of the corporation. Pag matigas ang ulo nila, na ginamit pa rin nila yung pinagbabawal na pangalan, that is contrary to what the commission has said, pwede silang i-held in contempt ng Securities and Exchange Commission. Now, let's go to Section 18. Now, itong Section 18, basic lang to siya. Let's read. Because Section 18 talks about the registration, incorporation, and commencement of corporate existence. Wala tong halos substantial change as compared sa wala tong substantial change when comparing to the previous code. Similar lang. Registration, incorporation, and commencement of corporate existence. A person or group of persons desiring to incorporate shall submit the intended name to the intended corporate name to the commission for verification. If the commission ito yung sinasabi ko kanina. Yung before mag-incorporate, nag-file na sila, nag-submit sila ng name sa commission para magpa-reserve. Ito na yun, see Section 18. Registration, incorporation, and commencement of corporate existence. A person or group of persons desiring to incorporate shall submit the intended corporate name to the commission for verification. If the commission finds that the name is distinguishable from a name already reserved or registered for the use of another corporation, not protected by law and is not contrary to law, rules, and regulations, the name shall be reserved in favor of the incorporators. The incorporators shall then submit their articles of incorporation and bylaws to the commission. Ito yung sasabi natin. Yung sinasabi ko kanina about sa already reserved. Before filing, magsasabi SEC, pa-reserve namin itong corporate name na gusto namin. Baka sakaling wala pang gumagamit nito. Sabi ng SEC, chinek nila, okay, wala pang gumagamit yan, approve, pwede nyong gamitin. Then submit your articles of incorporation and other necessary documents. If the commission finds that the submitted documents and information are fully compliant with the requirements of this code, other relevant laws and rules and regulations, the commission shall issue the certificate of incorporation. So, basic na discuss na to. A private corporation organized under this code commence its corporate existence and juridical personality. Ito, nasabi ko na ito kanina. From the date the commission issues the certificate of incorporation under its official seal and thereupon the incorporators, stockholders, members, and their successors shall constitute a body corporate under the name stated in the Articles of Incorporation for the period of time mentioned therein unless said is extended or the corporation is sooner dissolved in accordance with the law. Di ba? The legal existence, the corporate existence, the juridical personality of the corporation starts from the date the Commission, the Securities and Exchange Commission, shall issue the certificate of incorporation, take note, under its official seal. From that moment thereon, pwede nang mag-act. Gagawin na ng mga incorporators, stockholders, members, and successors kung ano man yung gagawin ng corporation in accordance with the law, of course. For the period mentioned therein, kung perpetual man yan, unless it is extended or the corporation is dissolved. Tandaan nyo, board exam question yan. Kailan nag-start ang legal existence ng corporation? At the date, the commission issues the article of incorporation. Ito, salient changes lang, not so much. The revised code includes provision on the requirements for the registration and incorporation of corporation prior to the commencement of corporate existence. Ito yun. Verification of intended corporate name prior to registration is now expressly provided. Dati implied lang yan. O ngayon, sinabi na sure, para mas mapadali yung process, submit nyo na agad yan. Pa-reserve kayo para ma-determine agad kung distinguishable yan or hindi. So, dito ngayon tayo sa Section 19. Now, Section 19 provides for the provisions of a de facto corporation. So, Section 19 states that the due incorporation of any corporation claiming in good faith to be a corporation under this code and its right to exercise corporate power shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. So medyo magulo, no? Anong meaning nito, sir? Anong basis ng concept ng Section 19 na to? Well, before we will discuss kung ano man pinagsasabi nito, let us first define ano ba tong de jure corporation and or a de facto corporation. Now, I know, sa obligations and contracts pa lang, napagdaanan nyo na yung meaning ng de jure, meaning ng de facto. Tapos ngayon, pagdating dito sa article sa corporation code natin, in-apply na tong de jure sa corporation, de facto sa corporation. And we have discussed this sa Title 1 kung ano to sila. But for now, yun, recap lang natin ulit or basically di-discuss natin. So, ang de jure corporation, it is one created in strict or substantial conformity with the mandatory statutory requirements for incorporation and the right of which to exist as a corporation cannot be successfully attacked or questioned by any party, even in a direct proceeding for that purpose by the state. Meaning yan, ang isang de jure corporation, it has an ironclad legal existence. Oo, bakit? Kasi it has properly complied with the necessary requirements for incorporation. And because of that proper compliance, naging ironclad, naging sobrang tibay ng kanyang corporate existence na even in a direct proceeding, na even though in a direct proceeding from the state, hindi matitibag yung kanyang corporate legal existence. Yan si de jure. Matibay siya. Pagdating naman kay de facto, a de facto corporation is one which actually exists for all practical purposes as a corporation, but which has no legal right to corporate existence as against the state. Against the state lang. Kasi tatandaan nyo kanina, di ba? Sinabi natin that an articles of incorporation is also parang contract siya between or an agreement siya between the state and the corporation, di ba? Sa previous slides natin. Ito na 'yon. Since wala siyang because it's a de facto corporation, walang legal right itong corporation na to, itong corporate existence na to as against the state. It is a corporation from the fact of its acting as such, though not in law or right a corporation. It is one which has not complied with all the requirements necessary to be a de jure corporation but has complied sufficiently to be accorded corporate status against third parties although not against the state. So yan sa de facto corporation. May defect, may error sa kanyang application, sa kanyang pag-comply for the incorporation, sa kanyang application sa incorporation niya. Merong defects, merong error. But despite those defects, despite those errors, etong si de facto corporation, for all practical purposes, yung mga acts niya as if isa siyang corporation na may legal corporate existence. But take note, that must be in good faith. Yan si de jure, properly complied. Not only a corporation in law, but also in fact. Kasi yung acts niya, corporation, meron din siyang legal existence. Sa de facto, meron yung acts niya, for all practical purposes, is a corporation. However, due to certain defects, dapat good faith to siya. Because of those defects, wala siyang legal corporate existence. Pero, he can still accord his corporate status as against to third parties. Pero hindi as against to the state. Yan si de facto corporation. Now, ano ang mga requisites para makturingan ang corporation na isang de facto? It is essential to the existence of a de facto corporation that there be a valid law under which a corporation with powers assumed might be incorporated. In this case, the General Corporation Act natin dito sa Pilipinas, the General Corporation Law, the Revised Corporation Code of the Philippines, Republic Act 11232. Yan, that is the valid law under which a corporation with powers assumed might be incorporated. Pangalawa, a bona fide attempt to organize as a corporation under such law. Ibig sabihin, dapat may attempt, hindi lang mere intent yan. Dapat may attempt talaga, bona fide. Like, pinakita niya talaga, may compliance talaga siya na nag-apply siya para maging isang proper corporation. Pangatlo, actual user or exercising good faith of corporate powers conferred upon it by law. Ito ang sinasabi natin kanina. It is a corporation in fact because for all practical purposes, that corporation, this de facto corporation, is acting as if he is a corporation with legal existence and that must be in good faith. Pangapat, ito usually wala tong pangapat sa mga books but basically, it does not have a certificate of incorporation. Now, stockholders of a de facto corporation enjoy exemption from personal liabilities for corporate obligations as do stockholders of de jure corporation. Now, existence of law. Basically, we're going to discuss the essential, the requisites ng isang de facto corporation. Una, yung existence of law. In order that there can be a de facto corporation, there must be a law authorizing it to be a corporation de jure. Kasi kung wala niyan, kung wala yung concept ng de jure, wala yung concept ng de facto. Kasi ang concept ng de facto nakadepende sa concept ng de jure. Kasi ang de jure, it is a corporation in law, corporation in fact. Ang de facto, corporation in fact lang. Naka-base sa corporation de jure yung kanyang de facto existence. So ulitin natin, kung walang de jure, kung wala ang concept ng de jure, wala ang concept ng de facto. Accordingly, there cannot be a corporation de facto under an unconstitutional statute, for such statute is void and a void law is no law. So, ibig sabihin, wala ang concept ng de jure kasi at the very first, yung statute that confers the corporate existence is void. So, wala ang de jure, wala ring de facto. Similarly, a corporation cannot be recognized as having a de facto existence when its purpose is prohibited by law or contrary to public policy. Isa yun sa mga defects. Neither can there be a corporation for the practice of a learned profession in the absence of a law expressly permitting the organization of such corporation. Like for example, ang accountancy profession, hindi ka pwedeng tayo ng corporation to practice accountancy. Hanggang partnership ka lang, if I remember correctly. So, because of that, hindi pwede. Hindi mo mako-consider as de facto yan. Kasi at the first place, walang concept ng de jure dyan. Kasi at the first place, walang nag-a-approve na batas na ang corporation pwede maging pwede mag-exercise ng ng accounting firm etc. So yan lang. Yan ang basis lang nito is kung hindi ka pwedeng magtayo ng isang de jure corporation, then hindi ka pwedeng magkaroon ng isang de facto. Kasi naka-basis ang existence ng isang de facto corporation sa kung ang de jure may defect at the first place. Kung walang de jure at the first place, di wala kang de facto. Yun, logical analysis lang yun. Ito, pangalawang requisite, a bona fide attempt to incorporate. When there has been no attempt in good faith to create a corporation de jure, there can be no de facto corporation. As you can see here, ang target sana at the first place is to create a corporation de jure. However, due to certain lapses, due to certain defects, due to certain errors, hindi na-achieve. So, naging de facto na lang. So, in this case, similar pa rin ang concept dito sa una. Kung walang de jure, walang de facto. Kung hindi mo inattempt mag-de jure, then hindi yan mako-consider na de facto. Dapat may bona fide attempt ka na corporation de jure talaga yung target mo. Kaso may problema lang, lapses, but you're in good faith, take note. Kaya, naging de facto. Any other rule might well open the door to fraud upon the public. Kasi, baka tinarget mo talaga at the first place de facto. Hindi yung pwede. Dapat, corporation de jure yung tinarget mo. Kaso nagkulang, kaya naging de facto na lang. Yun take note. Target is de jure, may pagkukulang, naging de facto na lang. Mere intent is not sufficient. Gaya na sabi natin kanina. Hindi lang, na sabihin mo, parang ano yan in addition, there must be a bona fide attempt to comply with the requirements of the law which goes far enough to amount a tolerable compliance with the law. Ang magandang example dyan, yung manliligaw mo. Just because he said na mamahalin ka niya habang buhay, na ikaw lang ang babae para sa kanya, na ikaw lang nag-iisa, na gusto kanyang ligawan, ibigay sa iyo ang lahat, ibigay sa iyo ang mundo. Pero sinabi niya lang yon, may intention lang siya. Yung intention na yon, hindi sufficient. Bakit? Walang bona fide attempt on his part to prove na ikaw lang yung babae para sa kanya, na ikaw lang yung mamahalin niya habang buhay, na ibibigay niya sa iyo lahat. There must be a bona fide attempt, mga kapatid. Kapag walang bona fide attempt, mere intent lang, Diyos ko, huwag mong sagutin yan. Kawawa ka. Dapat may bona fide attempt. There must be a tolerable compliance with the law. Oo, dapat sinubukan niya. Dapat tinarget niya maging de jure para masabing may bona fide attempt to incorporate. Huwag lang mere intent. It's not sufficient. Just because he said na mahal ka niya, hindi naman niya pinakita. Huwag mo yung paniwalaan. Now, creation of a corporation precluded. Precluded means prevented. Yun ang mean precluded. Creation of corporation precluded. The following are the examples of defects which will preclude the creation of even a de facto corporation. Meaning, kapag ito nag-i-exist, itong defects na to, kahit de facto, hindi yan pwede makonsider. Oo. Kahit de facto, hindi yan makonsider. Absence of articles of incorporation. Bakit? Kasi the mere fact na wala kang articles of incorporation, it means wala ka talagang attempt na maging de jure corporation. Wala ka talagang bona fide attempt na mag-incorporate properly, tolerable compliance to the law. Kasi 'di ba, yan naman talaga ang pinakakailangan para maging corporation ka, para i-approve ka ng SEC. At the first place wala ka niyan, wala kang bona fide attempt. So that precludes you from even being classified as a de facto kasi wala kang bona fide attempt. Kalokohan. Mag-apply ka ng corporation, wala kang articles of incorporation. Ibig sabihin, hindi mo talaga target na maging de jure at the first place, di ba? Now, failure to file articles of incorporation with the Securities and Exchange Commission. Ito rin. Alam mo naman, nasa SEC tayo magpa-file ng articles of incorporation. Bakit di ka nag-file? Ibig sabihin, wala ka talagang target maging corporation de jure. Kasi tandaan natin, ang target dapat is maging corporation de jure para masabi mong may bona fide attempt. na may colorable compliance to the law. But because of certain defects, naging de facto na lang. But in this case, itong mga to, lack of certificate of incorporation from the Securities Exchange Commission, so I guess tatanggalin ko to. Oo, pwede nyo itong masabi na na supplementary lang. Kasi di ba gaya na sabi ko kanina, usually wala to sa mga books tong pang-apat. Etong pang-apat kasi nasa book ko to siya, nasa Corp book ko siya. Kasi pinasulat to sa amin ng previous attorney namin, previous Law on Partnership and Corporation Code teacher namin, na ito, lagay na lang, das na tab COI. Kaya nilagay ko rin dito. Kinopya ko lang sa book ko. Parang supplementary na lang to siya. Parang additional evidence na there's a requisite for a de facto corporation. But here, sinabi dito, lack of certificate of incorporation does not preclude the creation of even a de facto corporation. But for this one, sabihin na lang natin supplementary evidence. Pero pwede nyo rin to i-disregard kung gusto nyo. Walang problema dyan. Nilagay ko lang to kasi nasa book ko. Ngayon, ito. Sabi natin, these defects will preclude even the classifying a de facto corporation as de facto. Kasi, as you can see here, it shows na walang bona fide attempt to incorporate under a de jure corporation. Di ba? Ito naman, itong pangalawa, this creation of de facto corporation results. Meaning, these are the following examples of defects which do not preclude the creation of a de facto corporation. Meaning, kapag nag-exist to, it will not prevent the creation of a de facto corporation. Meaning, pwede nyo gamitin na defects na to para masabing merong de facto corporation. Yun lang yung meaning yun. Dito, hindi nyo pwede masabi na may de facto. Dito, pwede nyong masabi na may de facto. Dito, hindi pwede kasi walang bona fide attempt. Dito, pwede nyo sabihin kasi may pinapakitang bona fide attempt. Like what? Articles of incorporation fails to state all the matters required by the code or state some of them incorrectly. Meaning, nag-file talaga ng articles of incorporation. May mga defects lang or errors dun. The name of the corporation closely resembles that of a existing corporation that it will tend to deceive the public. Not distinguishable. The incorporators or a certain number of them are not residents of the Philippines. The acknowledgement of the articles of incorporation or certificate of incorporation is insufficient or defective in form or it was acknowledged before the wrong officer. The percentage of Philippine ownership, stock required, less than prescribed, minimum paid capital, failure to submit bylaws on time. Kasi dito, pinapakitang may bona fide attempt. Take note, dapat may good faith rin dito ha. Hindi to bad faith. Dapat may good faith rin. So, ito, pag may mga ganito, you may say na it is a de facto corporation because it shows na may bona fide attempt and take note, it must be in good faith. The above may be considered as inadvertent or minor defects or error which can be excused to prevent injustice. Ito na-mention natin dito ang good faith. Sana yun? Exercise good faith ng corporate powers. To create a corporation de facto, it is not sufficient to show the existence of a law under which a corporation might be formed and an honest attempt to comply with the requirements thereof, but it is also necessary to show an actual user or exercise of corporate powers or franchise. Meaning, di ba sabi natin, for all practical purposes, this de facto corporation acts as if he is a true corporation with legal existence. Kaya sinasabi dito, na para makonsider kang de facto, dapat nag-exercise ka talaga as if, nag-exercise, you're exercising acts as if you have a legal corporate existence. But take note, it must be in good faith. Yun lang yun. User contemplated. The acts relied upon as showing user must be corporate acts as distinguished from acts which might as well be performed by an incorporated association or from acts of individuals which would not be corporate acts if there were a charter. Meaning yan, gaya sabi natin, this corporation acts as if he is a corporation na may legal existence. It must be corporate acts. Specifically sinabi yan. It must be corporate acts. Duty to correct defect if discovered. Furthermore, it is essential that the corporation must act in good faith in claiming to be a corporation and exercising corporate powers. Kasi, alam mong may defect. Kung kailan mo, pag nalaman mong may defect, tapos, kita mo, chicken, may defect tayo dito. Kailangan natin tong ayusin. Yan. It will show na may good faith ka at the first place. Pero pag hinayaan mo lang yan, kapag may knowledge ka na may defect, tapos nag-continue ka pa rin mag-exercise ng powers mo without fixing that defect, wala nang good faith doon. Mahirapan ka nang i-prove na may good faith doon. So, dapat, upon discovering the defect, ayusin agad. Para sabihin ng SEC, good faith to, mabait to. Kasi nung nalaman nila may defect, then, inayos nila, good faith to. Kasi mahalaga yan sa pag-determine ng de facto. Kapag de facto ka, wala kang masyadong problema. Oo. Delikado yan pag na-estopel ka. Later, estopel tayo. Ito, basis of de facto corporation. The recognition of a de facto existence has been found necessary to promote the security of business transactions and to eliminate quibbling over irregularities. Bakit? Kasi simpleng irregularities lang yan ang de facto Yung simpleng defects lang yan. Madaling maayos yan. So, wag na problemahin kung madali namang maayos, di ba? A third person dealing with the corporation will rarely be prejudiced if the company is recognized as a corporation in spite of minor defects in its formation. Para madalian na lang. Seldom would it be just to allow a wrongdoer to quibble over such objections to escape liability of wrongdoings, considering minor defects lang yan ng irregularities. Equally, it would be unjust to allow a claimant against a supposed company to assert the individual liability of innocent passive investors on the ground of flaws in the formal steps of incorporation, when they have attempt in good faith to comply with statutory requirements and the objecting party is not prejudiced. So, parang in-expand lang nito yung sinabi ko, di ba? Na over the simple defects, over the minor defects, the minor errors, wag nang palakihin yung issue. Kasi minor defects and issues lang yan Minor defects lang yan, minor errors lang yan. Wag nang palakihin yung issues. Kaya, yan ang sabi ng, Kaya when it comes to these things, it will be treated na as if proper corporation si de facto. Para, itong mga quibblings na to, itong issues na to, hindi nalalaki. Kaya ang trato na lang kay de facto pagdating sa third parties, pagdating sa third parties, is as if he is a proper corporation. Para hindi na palakihin yung issue. Yan yung basis ng de facto doctrine. Simple explanation lang. Kasi ganun naman talaga yung nature niya. Now, ito, na-state dito, di ba? Sana each right to exercise shall not be inquired into collaterally in private suit. Such inquiry may be made by Solicitor General. So, ito, anong meaning yan, sir? I guess nanonood naman kayo ng news, di ba? Questioning validity of corporate existence. The well-settled rule is that assuming that a de facto corporation actually exists, its existence as a corporation cannot be collaterally attacked either by the state or by private individuals. Take note, pag collateral attack, bawal both for the state and private individuals. Anong collateral attack, sir? Questioning the corporate existence. Basically, sinasabi mo, totoo bang corporation ka? Yun lang. Totoo bang corporation ka na may proper legal existence? Yun yung questioning the corporate existence. But if you will question the corporate existence collaterally, ibig sabihin, parang hindi yan yung main focus ng attack mo. Collateral lang. Pangdagdag sa pangdagdag sa pangdagdag puwersa sa main attack mo. Hindi pwede. Kahit na state or private individual sa mag-question dyan. However, the state can directly attack that. Oo, kasi provided Tingnan nyo. Such inquiry may be made by the Solicitor General in a quo proceeding. Meaning yan, the state can directly question the corporate existence. Paano? Ito, the state must bring a direct proceeding. Tawag dun quo warranto. Sir, anong quo warranto? Basically, ang quo warranto class it is an act, it is a petition, it is a process in which you are questioning the authority of an entity when it comes to exercising their powers. Ibig sabihin, ganito yan. You are questioning the authority that gave the entity the right to exercise its powers. You are questioning the authority that put the entity into that position to exercise the acts, to exercise its powers. For example, yung ginawa nila kay dating Chief Justice Sereno. Question nila, hindi yung impeachment kasi, you're questioning, di ba? You're questioning the acts performed by the Chief Justice after she became a Chief Justice. Yun yung impeachment. Iba yung quo warranto. Yung quo warranto, question nila yung appointment ng Chief Justice, yung legality, yung legality ng appointment ng Chief Justice. Sinasabi nila na at least as approved by the Supreme Court, sinabi nila na yung appointment ng Chief Justice is not proper. So, ibig sabihin, at the first place, hindi siya pwede maging Chief Justice. Kaya siya natanggal. Hindi na kailangan ng impeachment doon. Kasi ang impeachment, you're only questioning yung acts pag Chief Justice siya. Pero yung quo warranto, you're questioning kung ano yung naglagay kay Chief Justice sa position. Yun yung quo warranto. Yung appointment, you're questioning that. That is a similar case here. Quo warranto rin. You're questioning the authority. You're questioning ano yung naglagay sa corporation into that position of legal corporate existence. You're questioning the authority that gave the corporation the right to exercise its power, the right to perform acts as if it's a corporation. Yun yung quo warranto. You're questioning, ulitin ko talaga to, you're questioning the authority that put the entity into that position. Yun yung si quo warranto. So yun, with that said, the state must bring a direct proceeding, a quo warranto, against the corporation to oust it from the exercise of corporate powers usurped by it and to have it dissolved. So far as the state is concerned, the distinction between a corporation de jure and a corporation de facto is that one can successfully resist a suit by the state, brought directly to test the rightfulness of its existence, and the other cannot. Ngayon, yan yun. Pag successfully na ano yung quo warranto, big sabihin sa isang de facto corporation, pwede tong ma-dissolve ang de facto corporation kasi kino-question ng state yung existence mo as a corporation, it is not proper. The state is not talking about the acts of the corporation. The state is talking about what put the corporation into corporation. Di ba? Ano yung naglagay sa kanya sa pagiging status as a corporation? They are questioning that. Kung hindi proper yung nagbigay sa kanya ng status as a corporation, then pwede siyang alisin doon. Yun si quo warranto. Yun yung direct proceeding. Yun yung nagse-separate as so far as the state is concerned between the distinction of a corporation de jure and a corporation de facto. Kasi si state, kahit iko-warranto niya si corporation de jure, it can resist the suit. Kasi yung authority na naglagay kay corporation de jure into a corporation status proper. So hindi yung successfully mako-question ng state na improper yung naglagay ng corporation status kay corporation de jure. As opposed kay corporation de facto, hindi niya yung ma-defend properly. Hindi niya yung ma-resist properly. Kasi yung naglagay ng corporation status sa kanya, hindi proper. Tinitingnan talaga yung source kung ano yung source na nilagay ng authority sa kanila. Yun yung nature ng quo warranto proceeding. As to individuals dealing with it as a corporation, there's no essential distinction. Oo. The stockholders or members thereof, may pumasok na langgam. The stockholders or corporation are alike protected from individual liability for debts except to the extent provided by the charter or the acts of incorporation. Kasi sabi natin, when it comes to third parties, itong si de facto corporation, para siyang proper corporation talaga. Pero pagdating kay state, between the state and this corporation, doon na hindi proper. Pero the corporation and the third parties, proper. Yun. Know the distinction. Ito. Direct attack or collateral attack of corporate existence. Direct attack is one whereby the state, in a proceeding brought for that purpose, attacks the existence of an association claiming to be a corporation. A direct attack can only be instituted by the government through the Solicitor General by a quo warranto proceeding. Ito, nagmali tayo dito. Dapat 19 to. Sir, ano yung Solicitor General? No? For those of you, ang Solicitor General, basically, ito yung attorney ng government. In this case, in this current administration, si Solgen Calida. Jose Calida ata yun. Basta si Calida. Siya basically yung attorney, personal attorney ng government. Marami siyang ginagawa. So, siya yung maglilid ng quo warranto proceedings against a de facto corporation or any quo warranto proceeding or any kung kailan nila, no? Now, a collateral one or a collateral attack is one whereby corporate existence is questioned in some incidental proceedings not provided by law for the express purpose of attacking the corporate existence. Ibig sabihin, hindi naman talaga yung existence, yung corporate existence yung ina-attack ng proceeding na yon. Napunta lang talaga yung isang attack sa corporate existence para patibayin yung main attack. Yun yung meaning ng collateral. Ito, illustration tayo. Upon failure of A to pay his debt, X corporation sued A. Now, can A interpose the defense that X, being a de facto corporation, has no right to exist as a corporation, therefore has no capacity to enter into any contract and sue in its own name? No. Bakit? Kasi si A is attacking the existence of X collaterally. The defense of A is merely an incident to the main action or principal case that the purpose of which is to enforce the contract of X and K. The debt, yung utang. The right of X to exist as a corporation can only be inquired into directly in a quo warranto proceeding which is brought precisely for the purpose and in this proceeding can only be instituted by the government to the Solicitor General and not by A. So as you can see here, okay, let's look at it as a collateral attack. Ang pinag-usapan dito is yung hindi pagbayad ng utang ni A kay X. Yun yung main attack dito. Yun yung main issue dito. Yung hindi pagbabayad ng utang ni A kay X Corporation. Now, itong si A, para pang dagdag sa defense niya na hindi siya magbabayad ng utang, sinabi niya na, de facto to si X. So, since wala siyang corporate existence, hindi ko siya babayaran ng utang. Wala kaming hindi valid yung contract namin. So, that is a collateral attack. Ang main issue, hindi pagbabayad ng utang, and to support that, and to support A's position, inatake niya yung corporate existence si X. Yun yung collateral attack dito. But take note, hindi yun pwede. Because you can only question the corporate existence of an de facto corporation first through a direct proceeding, a quo warranto proceeding, initiated or instituted by the state through the Solicitor General. Na first thing dito, it is a collateral attack. Second thing, third party, hindi state yung institute ng attack sa kanyang corporate existence. So, bawal na bawal talaga. O, take note ha. So, yan yung meaning ng collateral attack. Pang support lang siya sa main attack. Ito, reasons for the rule against collateral attack. So, bakit pinagbawalan yung collateral attack sa isang de facto corporation? But later on, malalaman nyo, yung collateral attack pwede gawin sa isang estoppel. Pero sa isang de facto, bawal. Direct proceedings dapat. The general rule against collateral attack upon corporate existence is based upon the ground not of equitable estoppel but of public policy. Bakit? Individual right is not invaded kasi it is the state's right and authority which are invaded and usurped. Kasi gaya na sabi natin, yung relationship between the corporation and the third party, kahit de facto yung corporation, is proper. Pero yung relationship between the state and the de facto corporation, hindi proper. Kaya yung state lang, through a direct proceeding, ang pwedeng mag-attack sa corporate existence ng isang de facto corporation. If the state which alone grants the authority to incorporate remains silent, an individual will not be allowed to permitted to raise the inquiry. Kasi si state lang pwede. It would produce endless confusion and hardship and probably destroy the corporation if the legality of its existence could be questioned in every suit to which it is a party. For then, no judgment could be rendered which would finally settle the question. Oh, kasi panggulo yan eh. Iko-question, lahat na lang i-question collaterally yung attack, yung corporate existence, magulo yan. Dapat isang attack lang through the state in a co-warrant to proceeding. Hindi yung collateral attack na, example, maraming kaso against sa corporation. Lalo na mga malalaking corporation, marami yung mga kaso. Ngayon, magiging disturbance yan na kung sa mga kaso na yon, iba yung main issue, tapos iko-collateral attack nyo yung corporate existence. Na, gulo-gulo yan. Disturbance yan. Kaya sabi dito, state lang ang pwede to a direct proceedings pag de facto. Likewise, the rule is in the interest of the public and essential to the validity of business transactions with corporations. So yan, public policy reason para sa rule against collateral attack. Kasi basically, magulo yan eh. Pag collateral attack sa isang de facto, magulo yan. Kaya state lang ang pwede to a direct proceeding co-warrant to. So let's go sa article sa section 20. So sa section 19 we talk about the de jure, the de facto corporations. In this section 20 we'll talk about corporation by estoppel. Section 20 provides that all person who assumes to act as a corporation, knowing it to be without authority to do so, shall be liable as general partners for all debts, liabilities and damages incurred or arising as a result thereof. Provided, however, that when such an ostensible corporation issued on any such transactions entered by it as a corporation or on any tort committed by it as such, it shall not be allowed to use its lack of corporate personality as a defense. Anyone who assumes an obligation to an ostensible corporation as such cannot resist performance thereof on the ground that there was in fact no corporation. So, anong meaning yan? But firstly, we must first define what is an estoppel or estop corporation or corporation by estoppel. What's up? So, estoppel to deny corporate existence. So, an unincorporated association, which association lang unincorporated association, which represented itself to be a corporation. Pero hindi naman pala talaga siya corporation at the first place. So, similar ito sa concept nung partnership by estoppel natin, di ba? O sa law on partnerships, yung similar concept to sa partnership by estoppel natin. Na wala naman talagang partnership at the first place, but they misrepresented themselves na partner sila. In a partnership. Yun, partnership by estoppel. Similar concept yun dito. Dito, unincorporated, ibig sabihin wala talaga incorporation, association, which represented itself to be a corporation, will be stopped from denying its corporate capacity. Oh, from this this sentencing pa lang, this term pa lang, magigets nyo na ano meaning ng estoppel, di ba? Will be stopped from denying its corporate capacity. Meaning, itong unincorporated association na to will be prevented, will be stopped from denying its corporate capacity in a suit against it by a third person who relied in good faith on such representation. Meaning, kapag inatake ng suit ng third person na to, good faith ng third person ito, itong corporation by estoppel na to, hindi nila pwedeng ma-deny na, bakit mo kami inatake as a corporation? Hindi naman kami talaga corporation at the first place. They will be prevented from doing that. They will be prevented from denying that. So, ulitin natin. Itong third person, basahin mo natin to. It cannot allege lack of personality to be sued or evade its responsibility for a contract it entered into and by virtue of which it received advantages and benefits. So, gaya na sabi natin, itong si third person, nag-rely sa representation ng unincorporated association na to, na corporation sila. Where in fact, hindi pala. Tapos nung nalaman niya, considering that he is in good faith, binato niya ng suit. Hindi nagdamit ng suit, ng kaso, ng demanda. Ngayon, itong mga taong to, behind this unincorporated association, hindi nila pwedeng gamitin as a defense. Na, bakit mo kami kinakasuhan na sa corporation? Hindi naman kami corporation at the first place Hindi nila pwedeng gamitin yun as a defense. They will be stopped. Yun. They will be prevented from denying its corporate capacity. Oo, they cannot allege na, there's a lack of personality here because there's no corporation in the first place. Oo, wala kaming filing ng and you cannot even consider as a de facto corporation kasi there's no there's no corporation to be talked about in the first place. So you cannot attack us as if we are a corporation. Sabi ni article ni section 20, no, that's not how it works. Since you misrepresented yourself as a corporation where in fact you are not a corporation, article section 20 said, no, you will be stopped, you will be prevented from denying that corporate capacity. You cannot allege that there's a lack of personality. Loko ka Niloko mo yung tao na corporation ka, nakipag-enter ka ng contract sa kanya, na yung taong yun, nag-rely in good faith na corporation ka based on your representation. Now, because of your kalokohan, you will not be, hindi ka tutulungan ng batas. Loko ka. You will be stopped from denying your corporate capacity. Yan, section 20. Thus, besides corporation de jure and de facto, there is sometimes a recognition of a third class known as corporation by estoppel, also known as ostensible corporation. Now, di ba nasabi natin ito kanina, last time sa ating Title 1 video, na itong ostensible corporation, di ba sabi natin, ostensible, parang as if ganito, yun pala hindi. Yung akala natin ganito, yun pala hindi. Ostensible, yun yung meaning ni ostensible. Kaya dito nakalagay, as if corporation, yun pala hindi. Kaya ostensible, corporation by estoppel. Terminologies. Now, foundation of and reason behind this doctrine. Bakit ganito? Sabi ni section 20. Anong reasoning? Anong rationale behind that? Corporation by estoppel is founded on principle of equity and is designed to prevent injustice and unfairness. When there is no third person involved in the conflict before that, yun, to prevent injustice and unfairness. Bakit? Kasi the mere fact that this loko-loko misrepresented themselves as a corporation para manloko, para manggago ng ibang tao. Of course, ipiprevent ng batas na ma-deflect nila yung suit against them. So sabi ng batas, no, you cannot deny the corporate existence in this suit against you by a third person who in good faith relied on your representation. This is to prevent injustice and unfairness para yung mga loko-loko hindi makatakas. Yun lang yun. Ngayon, when there is no third person involved in a conflict arises only amongst those assuming the form of corporation who, therefore, know that it has not been registered, there is no corporation by estoppel. So, anong meaning yan, sir? Lumalabas lang si corporation by estoppel kapag mayroon ng third person involved. Okay? Lumalabas lang, nag-a-appear lang yung existence ng isang corporation by estoppel when there's a third person involved. Nagkaroon ng conflict. Oo. Nagkaroon ng damage pa, prejudice kay third person. So, pag gano'n na nangyari, di na dyan si corporation by estoppel. Pero pag walang involved na third person dyan, walang corporation by estoppel. Oo, kasi di ba? Principles of equity and to prevent injustice and unfairness. Pag walang third person, di walang prevent injustice and unfairness dyan. Walang principles of equity, so walang corporation by estoppel. So, kailangan mayroong third person involved. Kasi itong si third person involved, because of his involvement, kailangan pumasok ng Section 20 to prevent injustice and unfairness dahil sa kalokohan na ginawa ng mga tao behind this corporation. Behind this ostensible corporation. Acting as if they are corporation where in fact they are not. Ito, gaya na sabi natin kanina, iba si estoppel, iba si de facto. A corporation by estoppel has no real existence in law. Si de facto meron. Si de facto meron. Excuse me. Ulit natin. A corporation by estoppel has no real existence in law. It is neither a de jure nor a de facto corporation, but it is a mere fiction existing for a particular case and vanishing where the element of estoppel is absent. Like, wala nang third person involved. And existing in a particular case lang. Like yung relationship between the third person and this association, this unincorporated association. It exists only between the persons who misrepresented their status and the parties who relied on the misrepresentation. Take note, good faith yung reliance nila ha. Its existence may be attacked by any third party except where the attacking party is stopped to treat the entity other than as a corporation. Ano meaning yan, sir? Yung except where the attacking party is stopped to treat the entity other than as. Ito, meaning yan, yung except tong attacking party, meaning yan, sanang natin. Itong attacking party in this case, except kapag bad faith yan sila. Yan. They are prevented from questioning or treating they are prevented from attacking or stop to treat the entity other than a corporation. Wait lang. So yun, take note ha. It exists only between the persons who misrepresented their status and the parties who relied on the misrepresentation. Take note, yung reliance dito, gaya na sabi natin, in good faith, na inisip talaga nila, oy, okay, corporation to. Sige, transaction tayo. Corporation yung pala, misrepresented lang. Yun. In this case, its existence may be attacked by any third party na nag-rely on the misrepresentation in good faith. However, when there's a case, the attacking party is stopped to treat the entity other than the corporation. Meaning, itong attacking party in this case, that is stopped to treat the entity other than as a corporation. Meaning yan, at the first place, alam na nilang wala talagang corporate existence yan. Hindi yan de facto, na hindi yan de jure. Alam nila na hindi talaga yung corporation. Kahit na nag-misrepresent yan sa corporation. So, kahit alam na nila na hindi pala yan siya corporation talaga, nag-enter pa rin yan in a contract with them, in a transaction. So because of that bad faith, kasi alam nila they are stopped from treating that corporation as a they're stopped from treating that corporation other than as a corporation. So so because of their bad faith, they will treat that corporation even though it is a estoppel corporation or a not corporation talaga. They will treat that as a corporation because of their bad faith. So yan na, malaking difference kung good faith or bad faith. Kung good faith, then doctrine of estoppel corporation, pwede. Dito, pag bad faith ka, hindi. So, ito, illustration tayo. Where a group of persons represented that their organization called X and Co. is a corporation when it is not, to Y who recognized it as such, and on this representation entered into a contract with Y, and without assuming to act as a corporation, entered into another contract with Z. In an action against them on such contracts, they are stopped from denying the corporate existence of X and Co. as against Y, but not as against Z. Neither is Y allowed to question or challenge the validity of the organization or information of X and Co. in an action by the latter against the former. If not all the associates participated or consented to the representation, as to them the doctrine of estoppel will not apply. If the group of persons would-be corporations does not qualify as a corporation, whether the jury, the facto, or estoppel, there is no corporation, and stockholders are individually liable. So, anong meaning ito, sir? Now, in this first scenario, itong group of persons na to, nirepresent nila ang sarili nila as an corporation under the name of X and Co. Even though they are not. They represent itself to Y, who recognize it as such, and on this representation, entered into a contract with Y. Yun yung first scenario. Yung second scenario, this same group of persons, without misrepresenting themselves as a corporation, entered into another contract kay Z. So dito kay Y, nag-misrepresent sila. Kay Z, wala silang misrepresent. Hindi nila sinabing corporation sila. In an action against them on such contract, they are stopped from denying. So itong group of persons na to, they are stopped from denying. They are prevented from denying the corporate existence of X and Co. as against Y. But not against Z. Kasi as against Y, they misrepresent themselves. As against Z, hindi. If not all associates participated or consented to the misrepresentation, as to them, the doctrine of estoppel will not apply. Oo. Hindi mag-apply sa kanila Wala naman silang kasalanan, good faith sila. Yung mga associates lang na nag-participate or consented to the misrepresentation. Sa kanila mag-apply ang doctrine of estoppel, they cannot deny, or they are stopped from denying the corporate existence. Ito naman, if the group of persons would-be corporations does not qualify as a corporation, whether de jure, de facto, or estoppel, then there is no corporation, and the stockholders are individually liable. Yun ay, individually liable lang sila kapag hindi sila na-qualify de jure, de facto, or estoppel man. Tandaan nyo yan. So yan. Basic lang. Parang inulit lang dito, no? Kung bad faith, kung good faith, yung third party, then, the group of persons who misrepresented themselves as a corporation is stopped from denying its corporate existence. Pero pag bad faith, yung third party, then, at the same time, they are stopped to treat the entity other than as a corporation. So, tingnan nyo kung yung third party is good faith or bad faith. Estoppel of persons dealing with the corporation. The stockholders or members of a pretended or ostensible corporation who participated in holding it out as a corporation are generally stopped or precluded to deny its existence against creditors for the purpose of escaping liability for corporate debts or for unpaid part of the subscription to stock. Meaning yan, itong stockholders and members, nagpretend sila. Paulit-ulit na lang to na corporation pala, yun pala hindi. So because of that, they are precluded from denying its existence. Baka sabihin, oh, wala naman talagang corporation at the first place so bakit mo kami nireklamuhin? Ganun lang yun. Pero since because of doctrine of estoppel, they are prevented from doing that. Because of fairness and to promote fairness and prevent injustice. Kalokohan ginagawa ng scapegoat. Hindi sabi ng doctrine of estoppel, no, that's not, you cannot do that. So also the third persons who deal with such corporation recognizing it as such and the pretended corporation itself is estopped from denying its corporate existence and raising the defense of its lack of corporate personality for the purpose of defeating a liability growing out of the contractual relationship between them. Same yan dito kay Y. Kasi gaya na sabi natin, etong group of persons over X and Co, they misrepresented themselves to Y. Etong si Y naman, knowing that, nakipag-enter pa rin ng contract kay X and Co kahit na alam niyang they are misrepresenting themselves as a corporation. Kaya pareho silang estopped. Si X and Co, yung mga group of persons behind that, they are estopped from denying the corporate existence against Y. Si Y naman, neither is Y allowed to question or challenge the validity of the organization or formation of X and Co in an action by the latter against the former. Bakit? Kasi si Y, at the first place pa lang, he recognized na misrepresentation pala yung ginagawa ng group of persons na to. So they are both estopped following this last sentence. Its existence may be attacked by any third party except by the attacking party who is estopped to treat the entity other than as corporation because of bad faith. Because at the first place pa lang, alam niya nang misrepresenting yung ginagawa ng mga group of persons na yun, na corporation daw sila. Alam niya na at the first place, pero tinuloy niya pa rin. So because of that bad faith, he is estopped from challenging, questioning the validity of the organization or formation of the corporation. Meaning, kahit siya, because of this estopped, because he is estopped, si Y, he needs to treat that as a corporation. Wala siyang choice because of his bad faith. Yan, ito yun. Lastly, all persons not stockholders or members who assume to act as a corporation, knowing it to be without authority to do so shall be, liable as general partners. Yan na. Yan yung dangerous pagdating dyan. Yan talaga, kaya hinuli ko yung nilagay dito. Kasi, basahin nyo to, dito, liable as, sana yun? Sana yung general partners. Taran. Sana yung general partners? Dito na pala. Shall be liable as general partners. Yan yung matindi pagdating sa corporation by estoppel. Kasi, di ba, pagbabalikan natin tong de facto corporation, yung mga stockholders and members, they shall not be personally liable. Kasi, good faith sila They were acting na corporation talaga sila. Yun pala, may certain defects lang. Pagdating dito sa corporation by estoppel, bad faith talaga sila at the first place. They misrepresenting themselves sa corporation even though they are not. Yun ang problema. Kaya they are liable as general partners for all debts, liabilities, and damage incurred or arising as a result thereof. So yan yung section 21 natin. Things to take note. Mga good things to take note. Group of people, an incorporated association misrepresenting themselves sa corporation. Yan, mga things to take note lang under section 20. Na kung saan yung third persons relying on that misrepresentation in good faith entered into contract with them. So, with that, those people behind the corporation by estoppel are estopped from denying the corporate existence kapag inatake na sila ng third person in good faith. Ngayon, wala tayong corporation by estoppel kung walang third person involved. Saan pa? Ngayon, kapag yung third person involved, pag hindi sa good faith, bad faith siya kasi alam niya at the first place na misrepresenting pala yung corporation pero nakipag-enter pa rin siya contract with them, then he has to stop to question to question or to attack the existence of to attack the corporate existence of the corporation by estoppel of the stop corporation kasi bad faith siya eh. So wala siyang choice, he needs to treat that corporation as to treat that group of people as a corporation because of his bad faith. Yan lang. Yan lang ma-take note. To take note about about under Section 20. Oy, bakit yung Section 21 na dito? 22 dapat. So, to end the discussion with Title 2, let us proceed to the last section which is Section 21. Now, itong si Section 21 basically talks about the effects of non-use of corporate charter, and continuous innovations. So, Section 21 provides that if a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, meaning yung issuance ng Certificate of Incorporation, its Certificate of Incorporation shall deemed revoked. Ibig sabihin, babawiin yung validity as of the day following the end of the 5-year period. The day following. Example, pag January 1, 2020 yan, after 5 years, January 2, 2026, doon marirevoke. However, ito naman, another scenario naman tong second paragraph. However, if a corporation has commenced its business, ibig sabihin may sinimulan. Dito sa first paragraph, wala talaga. Dito sa second paragraph, may sinimulan na. But subsequently, becomes inoperative for a period of at least 5 years, 5 consecutive years, consecutive. The Commission may, after due notice and hearing, place the corporation under delinquent status. Now, basically, itong delinquent status, meaning yan, parang nasa delinquent, ibig sabihin, it is a status in which this particular corporation has not complied with the necessary requirements. Delinquent nga, delinquency. Ngayon, in connection with that delinquent status, a delinquent corporation shall have a period of 2 years to resume operations. Pag pinatawan na siya, pinace na yung corporation under delinquent status, with that, a corporation or a delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements that the Commission shall prescribe. Upon compliance by the corporation, the Commission shall issue an order lifting the delinquent status. Failure to comply with the requirements and resume operations within the period given by the Commission shall cause the revocation. Babawiin ulit yung validity ng kanyang Certificate of Incorporation. The Commission shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to the suspension or revocation of the Certificate of Incorporation of companies under their special regulatory jurisdiction. So, anong piniprescribe? Anong pinopoint out nitong Section 21 natin? Dalawa ang pinopoint out niya. First, non-operation within 5 years from obtaining the Certificate of Incorporation. The second one is the non-operations after commencing business for 5 consecutive years, putting the corporation in delinquent status. So, ito, salient points and remarks as compared to the old corporation code. So, the revised corporation code extended the period in which a corporation may not operate or use its corporate charter from 5 years to 2 years before it is deemed revoked. So, tinaasan. Kasi easement of operation ang binigay ng bastas natin, di ba? Sa intro natin. Pinadali. It further provide a more detailed guidelines as to the revocation of the corporation, lalo na pagdating sa delinquents. So, statutory, itong mga concepts ito, parang parang additional notes ba? Additional concepts. So, statutory requirements before and after incorporation. So, our corporation law contains various requirements, marami, di ba? And conditions which must be complied with in order that persons desiring to be so may become a body corporate kapag finalo nila yung mga requirements na yun. The courts have established between mandatory and directory conditions. So may dalawang guidelines or may dalawang types when it comes to those various requirements and conditions. The mandatory ones, and the directory ones. The rule is that as to provisions of the statute which is mandatory, non-compliance with its term will prevent the creation of a de jure corporation, but as to those provisions which are merely directory, a departure will not have this consequence. Ano meaning yan, sir? Ang ibig sabihin niyan, yung mandatory, if it is compelled, you are compelled to follow. You are compelled to comply. Sir, parang synonym lang naman yun, sir, yung mandatory ang compelled. Tama naman, synonym lang. You are compelled to test it out. Pinipilit ka, you are forced to comply. Because if you will not comply, then you cannot create a de jure corporation, a corporation both in law and in fact. Ito namang directory conditions, there are merely guidelines. Walang masyadong malaking impact if hindi mo ba follow. Oo, guidelines lang yan sila. As compared sa mandatory, it is compelling. Now, pagdating nyo sa law school, yan, isa yan sa mga statutory construction doctrines, kung anong difference ng mandatory sa directory. But yun lang, mandatory, compelled, you are forced to comply. Directory, guidelines lang yan. Strict compliance with the terms of statute is not required. Pagdating kay directory. The law requires the law requires only substantial compliance. Of course, what constitutes substantial compliance is a question to be determined in each case. So, case-to-case basis yan. It does not follow, however, that because a substantial compliance is sufficient, any positive statutory requirement may be omitted on the ground that it is unimportant. Yun, papasok na yung mandatory. These are conditions that cannot be dispensed with. So, case-to-case basis yan. Pero pag kailangan talaga, may positive statutory requirement, ibig sabihin, mandatory yan, hindi mo pwedeng i-disregard yan. O the ground na, di naman yung importante. Positive statutory yan Ibig sabihin, kailangan mong i-follow. That is mandatory. Gets? So, bakit hindi ni-discuss yan? Ang connect yan sa pagdating sa corporation code? Ewan, di ko rin alam. Joke lang. So, mandatory and directory provisions explain. Generally, mandatory provisions prescribe formalities for incorporation which are designed to protect the public. When a provision is construed as a directory, it is regarded as relatively inconsequential so that failure to comply with directory provisions will not be fatal to a valid corporation. Mandatory conditions may be either condition precedent or condition subsequent. So similar meaning lang. Pag mandatory, dapat pina-follow yan because it is designed to protect the public. Non-compliance will affect the validity of the corporation, the validity of its legal existence. Pagdating naman sa directory, guidelines lang yan. Inconsequential ang hindi pag-follow sa kanya. It will not have a fatal effect on the validity of the corporate existence as compared kapag sa non-compliance with mandatory provisions. And mandatory provisions divided into two, precedent and subsequent. From the word itself, alam natin ang precedent before, subsequent after. So, conditions precedent, explain. So, conditions precedent are those conditions na kung saan kapag hindi nag-comply, will prevent the legal existence of the corporation. So, meaning, itong mga conditions na to, it must be properly complied before mabigyan ng legal existence ang isang corporation. Ano-anong examples yan? Filing of articles of incorporation with the Securities and Exchange Commission and the issuance of the Certificate of Incorporation by the Securities and Exchange Commission. So, as you can see here, pinapakita talaga na precedent yan before. Kasi pag hindi yan na-comply, walang corporate existence at the first place. Walang legal existence ang corporation at the first place. Kaya president before. On the other hand, going to subsequent, conditions subsequent are conditions to be complied with after acquiring corporate existence in order that a corporation may legally continue as such. Ibig sabihin, kahit na meron na siyang corporate existence, there's still compliance na kailangan gawin ng corporation para ma-maintain niya yung status niya as having a legal corporate existence. And that is condition subsequent under mandatory provisions. Anong mga samples yan? Under this section, the two required acts of organization and commencement of its business operations are conditions subsequent, which are, ito, dapat mag-operate within 5 years from the granting o from the issuance of the certificate of incorporation, yung una. Ito naman, after commencing its business, dapat hindi lalampas ng 5 consecutive years yung kanyang in operation. Yan yung dalawang condition subsequent provided in this section 21. Non-compliance with these two will affect the validity of the legal corporate existence. Condition subsequent. Non-compliance with the condition subsequent, it is mandatory, may not affect corporate existence, although it can be a ground for proceedings by the state to forfeit its charter. An example is the keeping of books and records required in this code. So yan, no? Conditions precedent will prevent the legal existence of a corporation. So before. Condition subsequent, meron ng legal existence si corporation. However, in order to maintain that legal existence, proper compliance ang kailangan gawin para hindi bawiin yung legal existence sa'yo. Mandatory provisions. So, yan. So, yan ang purpose yan. Ito ang diniscuss natin. Para ipakita lang yung importance nila complying. Ito, last notes na lang natin. Formal organization and commencement of business, a corporation achieves legal existence from the date the commission issues a certificate of incorporation under its official seal, but formal organization brings tandaan nyo, formal organization brings the corporation to life. So, yung pag-issue lang ng certificate of incorporation, it only gives legal existence. But in order to give the corporation to bring it to life, there must be formal organization. Ito na yung 4. Si acts constituting formal organization, formal organization corporation is the process of structuring the corporation so that it can carry out the purpose for which it has been incorporated. So, dyan na, mag-start yung adoption of bylaws, election of the board, pino-formalize na yung organization. Pangalawa, substantial compliance sufficient. Strict compliance with this condition subsequent is not required. Thus, in a case a corporation was deemed to have formally organized, it appearing that from the very day of its formation, the corporation had a governing board which directed its affairs, as well as treasurer and a clerk, and that through these instrumentalities, it actually functioned and engaged in the business for which it was organized, and therefore, it could not be held to have forfeited its charter simply because it had not specifically shown that it also had a president and a secretary. So, anong meaning niya siya? Pagkahaba-haba. Substantial compliance lang, swakto na. Hindi strict compliance. Na-mention natin to kanina. Strict compliance, hindi ang kailangan. Substantial lang, goods na. Mapakita mo lang na may substantial compliance ka, goods ka na. Pangatlo, acts constituting commencement of business. A corporation shall be considered to have commenced the transaction of its business when it has performed preparatory acts geared toward the fulfillment of its purpose for which it was established. Yan, acts constituting commencement of business. Kapag sinimula Kapag sinimulan mo na, nagpakita ka na ng acts para ma-achieve mo, para ma-perform mo na kung ano ba yung purpose ng corporation at the first place, constituting commencement of business. Parang si Dito Corporation, di ba? Yung Dito, nag-start na sila. Di ba? Ang deadline sa kanila is by December, dapat mapakita na nila na kaya na nilang mag-operate. So yun, that is an act constituting commencement of business. May mga cell site na sila, nagtayo na sila ng mga hubs, mga tawag dito, offices, cell sites, di ba? Nag-start na sila mag testing ng kanilang ng SIM card. That is an act constituting commencement of business. Pinapakita na nila that they are complying or they are already on the process of fulfilling kung ano ba yung purpose ng kanilang corporation. Why was it established in the first place? And lastly, effects of subsequent continuous in operation. Where the corporation has commenced the transaction of business but subsequently becomes continuously inoperative for a period of at least 5 years, then it shall be declared delinquent by the commission. So going back here, so ito, as we have said, na delinquent status siya 5 years consecutive in operation. So yun, i-check na yun ng commission. So bibigyan ng chance yung bibigyan ng chance ng commission yung delinquent corporation para mag-operate ulit. Pero pag hindi na sila magko-comply, edi i-revoke na yung kanilang corporate registration. Hindi na sila magiging corporation, kawawa naman sila. So yan lang. Title 2. Basically, yung pinag-usapan natin dito sa Title 2 is about how a corporation is being formed. Paano pinapanganak ang isang corporation. So with that, medyo pasensya if wala ako sa condition ngayon. Kailangan natin tapusin ang lesson na to. So with that, bye-bye. Love you.